May I please understand?
Yes.
Paid for listening criminal revision tomorrow, Your Lordship. I filed on 14, but it's not listed. But I guess challenging the order of first appellate court session court, Your Lordship.
Can it be next week?
Next date fixed on London trial court. 1 month has granted for filing appeal. Next date is fixed on
Appeal?
26. Appeal.
Is it an appeal or what?
It is revision, Your Lordship.
Next week,
against the order of-
Tuesday.
The date is fixed by the trial court is for submitting.
When?
The circuit court.
When?
1 month has granted for Your Lordship.
Oh, that will not change. Tuesday.
Monday, Your Lordship.
Monday is holiday. It is holiday, Tuesday.
May it please the Lordship. Lordship, I beg to mention a matter for listing. My lord, a criminal petition, my lord. The matter was last listed in 2022.
With the court master.
I'm grateful, my lord. I'm grateful.
May I please? Your
Yes.
Lordship, I beg to mention that item number 15 of the list, my lord.
50.
15,
15.
15. I am appearing for petitioner, my lord.
Hmm.
My lord, conducting counsel S. Sharma is not well. Conducting counsel S. Sharma is not
Okay,
well.
on the prayer of Mr.
Health issue. S. J. Kolita.
S.J. Corridor and Council being put a petition, the case is passed for the day.
Fix the matter on next week, my lord. Fix the matter on next week,
Okay, did you next week?
27 August.
Did you?
Please, Lordship, I pray for listing a criminal petition. My Lordship, it last listed on in the year 2024. May it listed in it.
Give it to the court master.
May I please the Lordship, I beg to mention one criminal petition, my lord, to come up for orders, my lord, on 27th or 28th.
Fix the date, court master will allot the date.
And my another criminal appeal, my lord. It is also for hearing, my lord. Last time.
Hearing. You make an application before the registry.
Lordship, I beg to mention a criminal petition for listing an admission column.
Okay, give it.
May I please, the Lordship, also I'm praying for listing of this matter tomorrow, Lordship. The big fact is that, Lordship, in this matter, I'm appearing for the accused person as the respondent. Now, what has happened, prior this Honorable Court has passed an order fixing it on 15th of next month, Lordship, September. Now, prior to that, Lordship, I moved before this Honorable Court for expeditious trial because one application was pending before this Honorable Court. And this Honorable Court has
Can
given
it
a
be on
direction
Tuesday?
within a month, Lordship. Yes, Lordship.
Can it be on Tuesday? Because tomorrow I am not sitting.
Then when is the
Female
Lordship?
bench,
When is the
witness.
Lordship?
As per roster,
Yes, Lordship.
I'm giving some other roster tomorrow.
May I please, Your Lordship. Item number 8 may be adjourned.
8. Okay, on the prayer of Mr.
A.S. Chaudhary.
A.S. Chaudhary. Now, counsel is paying for the petition and the case is passed over for the day. PP. Regina.
May I please, Your Lordship? Lordship, therefore mention of a criminal petition.
Bit louder, madam.
Listing of a criminal petition, Lordship. Listing of a criminal
Okay,
petition.
give it.
May I please, I'd like to mention item number 4, 5, and 7, your Lordship.
4, 5,
And
and 7.
Yes, your Lordship. Your Lordship, similar matter was, I made a mention yesterday also.
Okay,
the matter was
when do you want?
27/8, your Lordship.
What are the other cases?
The other cases, your Lordship, 2 were mentioned and the date is fixed on 27.
Okay,
And one I'm praying for listing of the similar matter on 27 also, your Lordship.
okay, likhijo. On the prayer of Miss S. Nazdin, the counsel for the petition list the case on 27. 4 ot likhibo, similarly 5 ot likhibo, or similarly 7 ot likhibo. And the other one, motion.
Other one, yes, for listing.
Motion.
Yes, motion matter.
Okay, 27.
Oblige you.
For withdrawal, item 36.
Sharply.
May I please?
Yes, your name?
If I Islam on behalf of.
I Islam. Mr. I Islam, learned counsel being for Mr. Anjay Dotto
N. Ahmed.
and Ahmed, learned counsel for the petitioner. Has submitted that the petitioner wants to withdraw the instant criminal revision petition. Mr. MP Goswami, learned additional public prosecutor who is in attendance, has submitted that state has no objection to the prayer. In view of above submission made by so and so.
May I please-
Criminal revision.
Lordship, my name is, I am
Okay.
the respondent, R.L. Sutia.
Mr. MP Goswami local people who are in attendance have submitted that the state and the respondent number 2 I have no objection to the prayer. In view of the above submission made by Islam. And counsel for the petition, the criminal revision petition is dismissed on withdrawal. Good.
37.
Yes, your name, madam?
Bidas on behalf of AM Ahmed.
Bidas.
Bidas.
According to email petition likhibo khali. Bidas, learned counsel appearing on behalf of, appearing for Mr. AM Ahmed.
AMN.
Okay, learned counsel for the petition. I can likhibo. Usami nalage aro. Nai, party no hai.
Daily list for motion. Item 1.
Please, Your Lordship.
Yes.
This criminal revision petition is filed against order dated 30th April 2025 as per the landed principles of
Interim
law.
maintenance,
Yes, against it.
8,000.
Yes, 2000.
Will you should notice at this stage?
Yes, Your Lordship.
Hard
Lordship,
base.
kindly be stay the operation of the order dated 30th April.
Then let us hear you. If we find any privacy case for staying, we'll stay.
Yes, sir.
Make submission then.
Lordship, the petitioner is earning a monthly income of, his income is rupees 12,000.
Let us see your statement of assets and liabilities.
Your Lordship, it is from page number 30.
Hmm. What do you do?
A shop owner. A joint shop owned by
Ah.
the petitioner and his elder brother.
General monthly expenses. Your name is Subhek Sharma,
Shubhek, sir.
43. What do you say about your income?
Your Lordship, I own a shoe shop along with my elder brother.
Hmm.
My elder brother is bedridden at present.
Have you mentioned so
Yes,
that you run a shoe shop
yes, Your
in
Lordship.
the statement of assets and liabilities?
Yes, Your Lordship.
Where is it?
In WS also.
No, let us see your assets and liabilities. That starts from page 48.
Should can directly mention.
Monthly income not applicable. Page 51. You are hiding your income. And your sister-in-law cannot be your dependent.
Yes,
Cannot be.
pardon.
Because she has her husband. Don't find.
The husband-
Shall we decline? Shall we decline the interim prayer? You are hiding something. You have not disclosed.
But am I,
You appears to be guilty of suppression of acts.
oh, Your Lordship.
In the statement, at least statement of assets and liabilities, you did not do so. And you run a shoe shop. The lady has a child also. Well, you should notice at this stage.
Yes, sir.
Don't find anything. If we decline, your case will be prejudiced. Hard miss,
Yes, sir.
as you had learned counsel for the petitioner. Post of the instant criminal revision petition is preferred. What is this bank statement? Is it part of the record?
Yes, part of the record, Your Lordship.
Part of the record?
Yes, part of the annexure D and E from page number 34 on.
This page 57 onwards are they part of the record?
Yes, part of the record. Your
Wherefrom we can see that it is part of the record?
Lordship, see, page number 57.
This is a statement now you have enclosed,
Yes,
which you have enclosed. Was it a part of the record in the,
yes, in the family.
wherefrom we can see?
Your Lordship, if you, file additional affidavit, where certified copies can be.
No. you have enclosed 100 pages, right, running from 57 to page 173 in this petition, right? Was it part of the case record before the family court?
Yes, your lord.
Where from we can see that these are part of the records?
Yes, Chip, I understand.
In your written statement, have you mentioned that I have enclosed the bank statements?
No, in written statements, this bank statement was not enclosed at that time.
Was not enclosed.
Evidence was.
Then in your statement of assets and liabilities, you have enclosed this.
Yes,
You have enclosed this.
I have enclosed it.
Where from we can see
Your
the
lordship-
supporting documents?
Lordship, this is not this actually from page number 57 onwards are not a certified copy of documents. Your lordship.
Okay, I am asking the question. Was these 100 pages part of the case record before the family court? Where from we can get it? That information that I have enclosed my bank statement. We don't think so.
Page number 52, paragraph number 9.
Page number 52.
52,
Page number 52.
number 9.
Paragraph number 9. Okay.
Furnish copy.
Last years. But why you have said monthly income 0? Not applicable? And you have projected your sister-in-law as your dependent when her husband is still alive to take care of her. Heard this so-and-so, this criminal revision petition. Under 442, BNSS is preferred to seal an order dated 30/04/2025 passed by the learned family, passed by the Court of Learned Principal Judge number 2, Family Court, Kamrup, Metro Guwahati Family Court, in FC Criminal Case number 259/2024. So before the family court, the opposite, sorry, the respondent herein has preferred an application under section 120, 125 over there, 125 and 144. 125 Code of Criminal Procedure. Seeking maintenance from the petitioner, impleading him therein as the opposite party. Post up by the impugn order dated 30/04/2025. The Learned Family Court has directed the opposite party therein, that is the petitioner herein, to pay an amount of rupees 8,000 per month as interim maintenance amount till disposal of the case FC criminal case number 259/2024. Post of being agreed by. The order dated 30/04/2025. The instant criminal revision petition is preferred. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice of the respondent by registered post with AD, as well as by usual process within 3 working days from today.
Item 2.
The criminal revision petition, challenging that
Concurrent finding,
1 year's
concurrent.
concurrent.
Where is the magistrate order?
My lord, Minister, annexure 2, my lord, and page
Page.
73, my lord.
Page.
58, my lord.
Page
58, my lord.
58.
58, my lord.
58. That is operative part. Starts from
And the starts from, my lord, page 17, my lord.
page 17. ZR case 324.
Paragraph now 29, accordingly, accused
Three.
Bolai Das is sentenced to undergo 1 year rigorous
Court
imprisonment,
three.
pay fine of rupees 5,000 rupees, in
Court of
default of
Judicial
SI for another 3 months under section 324 IPC. The period of imprisonment already undergone by the convict is set up and it will run concurrently.
Did you undergo some period?
My lord, 3 months already undergone.
3 months?
My lord.
Have you stated so?
My lord, not stated, my lord, but as per my instruction, my lord.
Any, anything regarding your arrest somewhere mentioned?
Lord,
Mr. At least we have to
That,
record something.
next day, my lord, he was arrested, my lord.
Have you made some statement? Have you made some statement somewhere?
Mention it, not
Huh?
mention, my lord.
To pass some order, we need some statement. Is it not?
Additional affidavit, my-
Is it not the minimum requirement that I have undergone this much period of custody? Heard Mr. K.R. Padgiri, Learned Counsel for the revision petitioner, and Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. So stop. The revision petition, criminal revision petition under section 442, read with section 438 of the Bharatiya Nagorik Surakha Hunita 2023 is preferred to assail a judgment, an order dated 17/3/2025 passed by the Court of
Session judge.
Session Judge Lakhimpur at North Lakhimpur within bracket Appellate Court in Criminal Appeal number 8 within bracket 2 of 2024. Full stop. By the judgment dated or an order dated 17/3/2025, comma, the Appellate Court while dismissing the criminal appeal, comma, has affirmed a judgment
Judgment and order at court.
an order dated 4/3/2024 of conviction and sentence passed by the Court of Judicial Magistrate First Class, Lakhimpur at North Lakhimpur in ZR case number 1117 of 2022 and PR police report case PRC number 1206 of 2022 post up by the trial court. The trial court had convicted the revision petitioner for the offense under section 324 Indian Penal Code and sentenced the revision petitioner to undergo one rigorous imprisonment for 1 year and to pay a fine of rupees 5,000 in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. The revision petition, I've gone through the grounds as in a revision petition, criminal revision petition. The revision petition admitted for hearing. The case records of criminal appeal number so and so and GR case number within bracket PRC case number be called for issue notice returnable in 4 weeks as Mr. Goswami has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of formal notice to the respondent number 1 is dispensed with. Extra copy of the revision petition. 3 working days. The revision petitioner shall take steps for service of notice on the respondent number 2 and the respondent number 3. Is there any scope for conciliation or what?
Yeah.
By registered post with AD as well as by usual process within 3 working days from today. Yes, Mr. Goswami, 1 month, 1 year.
1 year.
Hard. Mr. K.R. Padgiri, Learned Counsel for the applicant stroke revision petitioner. And Mr. MP Goswami, Learned Additional Public Prosecutor for the opposite party. Stroke respondent number 1, State of Assam. Post of the instant application is preferred, seeking suspension of execution of the sentence passed against the applicant stroke revision petitioner and for his release on bail. Post of the applicant as the revision petitioner, I can look it. It is submitted on behalf of the applicant rate petitioner or revision petitioner that during the period of investigation stroke inquiry stroke trial, he was in custody for about 3 months. Post of. It is further submitted that at the time of commission of the offense, the applicant revision petitioner was a student. Post of. Having regard to the projections made above, it is observed that pending disposal of the accompanying criminal revision petition, number to deliver criminal revision petition number so and so, which has been admitted today for hearing. It is on that execution of the sentence passed against the applicant, the stroke revision petitioner shall remain suspended and the applicant stroke revision petitioner shall be released on bail 10,000 with 1 COT, satisfaction of the trial court.
Oblige.
Item 3.
May I please, Your Lordship? Lordship,
Yes.
referred a criminal revision against the order of a Zimma. The impugned order is at page number 12, Your Lordship.
Yes, Mr. Goswami, get a status report.
Status report, man. But perhaps he is not the person from whom seized, no?
Yes, Your Lordship, the case is that I am not an FIR named accused. I was not forwarded. After 20 days, this is a matter relating to Tejpur. In Guwahati, in one printing press, the police came to search something. I was a stranger who was present at the place of seizure in Guwahati. And thereafter, the police.
What
very
is the,
successfully-
what is the offense? So let us
The
see the
offense is
FIR.
regard to printing of fake currency notes, your lordship.
Fake
Ah,
currency note,
Fake currency.
Fake currency.
lordship.
Whereas I am a
Well,
stranger to the entire case, your lordship.
That the investigation will reveal.
Reveal, my lord.
Indeed, your
How much? 1,21,100.
Yes, yes.
And
It
where is
is
your
seized.
seizure list?
Yes, yes, my lord. It is seized from his, page
From
19,
my
my lord.
possession.
Page
Page 19, my lord.
19.
Below, description of seized articles. My lord.
You
One
are an
mobile
owner of the
phone.
press.
I'm not owner of the press, your lordship. I
You
was
are,
present at the press when the police came to search something from the owner of the press, your lordship. I was merely
let us
present at
see
the
the search and seizure. Page
Page 19, lordship.
2019. Heard Mr.
TL also, your lordship.
E.A. Loskor, learned counsel for the petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent state. Full stop. The instant criminal revision petition under Silvo cost title, read with so and so, is preferred to assail an order dated 20/20/6/2025, passed by the Court of Learned Sessions Judge, Unitpur at Tejpur, Trial Court, in connection with ZR case number 508/2025 and Tezpur Police Station case number 206/2025, whereby the Learned Trial Court has rejected an application preferred by the petitioner seeking interim custody of a mobile phone. Post of the ground of rejection of interim custody, as appears from the order dated 20/06/2025, is that the mobile phone, the seized mobile phone, will be required for further investigation, as per the report of the investigating officer of the case, post of para. The case, Tejpur Police Station case number 206/2025 has been registered for the offenses under section 179/3 within bracket 5 B and S likhibo purato on One 4/2025. After seizure of currency notes, suspected to be fake, amounting to rupees 1,21,200 from possession of two accused persons named page 16 Rajesh Das and Keshav Sarania. Post. Subsequently on 23/4/2025, the mobile phone of the petitioner was seized. Wide a seizure memo, MR number 278 of 2025. Also, issue notice returnable on so and so. As Mr. Goswami has appeared and accepted notice dispense with her. An additional public prosecutor is to obtain a status report from the IO as regards current status of investigation of Tezpur Police Station case number so and so. And also as regards requirement of the seized mobile phone. As regards any further requirement for retention of the seized mobile phone. Much obliged. To place the same on the returnable date.
15-9. Item 6.
May I please, Your Lordship? Your Lordship, the instant revision petition has been filed, Lordship. Against
What is
the
your trial court judgment?
Trial court,
Page 15, Lordship.
Page 18,
Lordship.
Tokwa Khana. 448. Before
Page
1 year.
1 year,
One
Lordship.
Heard Mr.
Abora, Lordship.
A. Borua, Learned Counsel for the revision petitioner. Agotu Nisne, huh? And Mr. MP Goswami,
Yes.
Learned Additional Public Prosecutor for the respondent number 1, State of Assam. The criminal revision petition under so and so. BNSS is preferred against a judgment and order dated 15/7/2025 passed by the Court of Learned Sessions Judge Lakhimpur at North Lakhimpur Appellate Court in Criminal Appeal number 21 (1) of 2024. First stop. By the judgment and order dated 15/7/2025, the appellate court, while dismissing the appeal, has affirmed a judgment and order dated 22/11/2024, passed by the Court of Learned Judicial Magistrate, First Class Tokwa Khana, in ZR case number 450/2020 and Police Report Case PRC number 18 of 2021. Post of the trial court had convicted the accused stroke revision petitioner for the offenses under Section 448 and Section 354 of the Indian Penal Code. First of all, for the offense under Section 354 IPC, the revision petitioner has been sentenced to undergo simple imprisonment for 1 year and to pay a fine of ₹6,000, in default of payment of fine, to suffer simple imprisonment for another 3 months. Post of for the offense under Section 448, IPC, the revision, he has been sentenced to pay a fine of ₹500. Post of. You spend any period in custody?
Yes, Lordship. 35
14 days.
Initially 14 days, Lordship. After the judgment, Lordship, the petitioner have not filed any petition for immediately for allowing him to bail, Lordship, criminal case bail, Lordship. So he is arrested, Lordship, 37/25, Lordship. 37/25, Lordship. Since then also, Lordship, today
Okay.
35 days.
Since then, 37 means today is
Today
total
is
35 days.
21 days and another 14.
I have gone through the grounds urged in the criminal revision petition. The criminal revision petition is admitted for hearing. Case records of so and so be called for to notice, returnable in 4 weeks. As Mr. Goswami has appeared, for one, the revision petitioner shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today. I go that it is submitted on behalf of the applicant revision petitioner that during the period of investigation stroke inquiry stroke trial, he was in custody for 14 days. Post of it is further submitted that after the judgment rendered by the appellate court, the applicant revision petitioner was taken into custody on 3/7/2025, and as on date, he is in custody serving the sentence. Post of it is submitted by the learned counsel for the petition applicant revision petitioner that till date, the applicant revision petitioner has spent 35 days in custody.
Yes, Lord.
About. Loud.
Item number 9.
If,
Yes.
I think if you look at.
Appeal.
Page 30.
Appeal. When an appellate provision
Yes.
is there, criminal petition is not to be entertained.
Make.
Do you have the BNSS?
No. No, Lord. It
Huh?
is under. Earlier one.
Huh?
And it is under.
Okay, let us have the CRPC.
CRPC, man.
Read 449 CRPC. Hired Mr. L.R. Mozumdar, 4492 Lady. Learned counsel for the petitioner, and Mr. MP Goswami, learned additional public prosecutor for the respondent state. Post of the instant criminal petition under section 528 of the Bharatiya Nagorik Suraksha Hanita 2023 is preferred to assail an order dated 29/7/2025 passed by the Court of Additional District and Sessions Judge Hojai in criminal miss within bracket B, case number 10 of 2022. Post of by the order dated 29/7. The order dated 29/7/2025 is passed under section 446 Code of Criminal Procedure. Code of Criminal Procedure. 446 within bracket 1 of the Code of Criminal Procedure with a further direction, with an observation that if the petitioner fails to pay the penalty by the next date, a suitable action under section 446 within bracket 2 CRPC will be initiated against him for recovery of the penalty. Post of as all orders passed under section 446 CRPC is appealable under section 449 CRPC, the instant criminal petition referred under section 528 B and SS, which is perimeter to section 482, CRPC is not entertained, reserving the liberty to the petitioner to prefer an appeal as per provisions of section 446 within bracket 449, BNSS, CRPC, which is perimeter area 2. Section 495. BNSS. When appellate provision is there, you can't file.
Right.
Item number 10.
Yes.
This case is pertaining to the quashing of a complaint case.
Complaint case.
My lord,
Where is the
Page
complaint?
number 75, my lord.
Page number
75.
75.
Six complaint.
76. Yes. Let us see. 79.
My lord,
Both the complaints are permanent resident of the aforesaid locality. Rameswar Deka, Salaur. Okay. On 16/9, while the construction of boundary wall of permanent office of Ahom Gana Porihad office under Dolgaon was going on, the accused persons, as per instruction of the accused number 1, had stolen 2 truck Stone Hill to. Is it an English translation or something?
English, my lord.
Let us see the original one.
Assamese portion, my lord.
Ah,
Page number 85, my lord.
okay. Dui truck Hill, Dui truck Bali. Cognizance taken.
My lord, notice issued, my lord, to
Ah.
the accused person. Page 75 is the notice, my lord.
Ah.
Notice received by all the,
Where is the order?
Order.
Before issuing notice,
my lord,
there must be an order.
order is
Please
there.
show
but-
the order.
Yes. There is an order, my lord, but.
Because my suspicion is that it is an order for your appearance
Yes,
to give hearing to
No.
you.
yes.
To give hearing to you under new section 223 perhaps.
That's
It looks like.
My lord,
Do you have the copy of the order?
my lord, order I could not,
Because page 81 is a notice, right?
my lord.
That you are challenging.
Yes, one date is over, my lord. That order I could not obtain the separate copy.
Because see, nowadays, new procedure. Before taking cognizance, that accused is to be heard. If that is so, please show him. Because the order, you read first 223 BNSS. If this is an order, then we will not enter in it. If this is an order after taking cognizance, then we might enter in it, right? Because you have a provision to place your case before the magistrate. Please, next case.
My lord,
Next
there is
case, after, I will take up your case after 1 or 2. We will not spend time here.
Item number 11.
provided section.
Lordship, my senior is now under, now court number 17, Lordship. After
Item 12,
Item 7.
Where, please, your lordship, my lord. Yes, it is
Application
for
428 of
for
complaint, my lord.
complaint case,
Yes.
quashing, quashing.
Page 14, yes, no. Page 14 is the complaint. my lord.
Page 14. Let me read Dinesh Kumar. Sir.
Yes, sir.
Yes,
Seems civil.
heard Mr. M.K. Boru, Land Council, for the petitioner, and Mr. R.R. Kosik, Land Additional Public Prosecutor for the respondent. Number 1, State of Assam. The instant criminal petition under Section 528 of the Bharatiya Nagorik Surakha Honita 2023 is preferred to assail criminal prosecution lodged criminal prosecution, criminal proceedings of complaint case number, CR number 1225 2025-24, presently pending before the Court of Planet Judicial Magistrate First Class Morigaon Trial Court. Any cognizance order?
No, cognizance is not taken by.
Huh? How did you know?
My lord, the orders I could not annex it. Okay. The next date is fixed for initial deposition of the complainant. Yes, get copy. Take copy.
What happened on 13/8?
My lord, I don't.
Same thing. Jumping the gun.
2 to 3.
No cognizance.
Only is not taken.
You were asked to appear so that you can object to the complaint petition.
Yes, Honor, but the petitioner.
That is why I have asked Mr. Ali to read
My lord,
the same reason.
yes, sir.
When you have an opportunity, yes, I know prima facie the complaint is clearly of civil nature. But when there is a provision, the court has only issued notice,
My lord.
right? So that you appear and apprise the court that no cognizance can be taken on this complaint. It is for that reason your appearance was requested,
Yes, my lord. But
not to file
they
a
have-
criminal petition just after receipt a notice, because all the forums are there, because everybody runs to the High Court
Yes, sir.
under the guise of 528, earlier 5482. This particular provision has been incorporated specifically to avoid filing of 528 petition or 482 petition. See, everybody is rushing. We have other, because magistrate court is competent enough to decide what is 420.
But this his
No
decision-
ingredients is
but
made out.
thing
You
is that-
go and appear and contest the case.
the
Will
thing
not
is that-
set precedent.
So we have to go, he has never stepped in Assam, in fact, before filing of this case. And he said, how can I go to Morabai? That is the place
Oh.
where he's
Okay,
a person where his dominance is very much entire.
okay.
There. So he extorted, still calling.
Yes, some exception.
Yes.
Hmm.
He's from Patna.
He can be
And there is apprehension.
apprehension.
There is apprehension.
কি লিখিলে? Huh? One of the contentions raised is that any notice received,
Yes, ma'am, he has received the notice, madam.
page?
The notice here, he has received a notice, was very ineligible, my lord, along with the
Page,
copy of the
page,
complaint. But I have not annexed that one.
You are not annexing.
Yes, madam.
Man,
So I
we-
obtained a
we-
certified copy of the complaint. Yes,
You are
madam.
asking us to guess.
And research.
You got it through WhatsApp or what?
No, he has handed over to me,
I
but
don't know.
it was not.
The petitioner is a resident of district Husseinabad, district Shekhpura, Bihar. And he had never visited?
Never visited.
Never visited Moira Bari district, Morigaon, Assam. Though the complainant respondent number 2 and the petitioner had business transactions. Full stop. It is also highlighted that in the complaint itself, the complainant respondent number 2 has mentioned that he transferred the alleged amount through bank transfer. Full stop. The petitioner has also expressed an apprehension of appearing before before the trial court on the apprehension before the trial court at Morigaon. Or full stop. It transpires that the petitioner has been put to notice in compliance of the procedures laid down in the first proviso to subsection 1 of section 223 BNSS. Mr. Kosik.
223.
First proviso.
First proviso.
Full stop. Para. The contents of the complaint petition are perused, and its privacy indicates its privacy the allegations privacy appear to be civil in nature. Issue notice returnable on so and so. As Mr. Kosik, respond number 1, the petitioner shall take steps for service of notice I'm gonna respond number 2. Registered post, AD, usual process, 3 working days. Having regard to the projections made above, colon, the contents of the complaint. What are ingredients of section 316 and section 318 of the BNSS? And considering that the petitioner is a resident of Bihar, it is ordered in the interim that further proceedings of complaint case number so presently pending before the court of shall remain suspended till the returnable.
Highly obliged, my lord.
17-9.
We can
Item
call for the scan copy.
It can be called for.
The scan copies of case record of CR case number be called for.
Highly obliged.
Item number 13.
Please, okay. Petition is filed for quashing of FIR.
Quashing of FIR.
FIR.
Let us have a look at the FIR.
FIR is page number 11, page 18.
Page number 18.
18.
Kingfisher, Budweiser. So, all brands.
All when it is like having one.
Magic Moment, 29 carton, containing so and so. Then mobile, Bolero. Okay.
Everything.
Who were apprehended? Bipul
Bipul Devi.
Koilan stated. How many?
There are
Deepak Dotto, Koilan Dotto, Joymo Jidung, Vedanta Madhav Bora, Sumanto Bora. We are dealing with Bipul Devi, Deepak Dotto, Koilan Jyoti Dotto. So, this one. Deepak Dotto. Then Koilan Dotto. Okay, Deepak Dotto, Koilan Dotto. They were apprehended.
apprehended.
Then
Then released on bail.
Bipul Devi. Bipul Devi. Okay. Yes. Then what happened? Arrested.
Arrested and then
Who?
released on-
All the petitioners were arrested.
all are
All 8, including the 3 petitioners. Okay. Produced. Perusal of inspection memo. Medical report. On jury. People have stated that he is suffering from papillary. Yes. Were remanded to judicial custody. When you were arrested?
that way of
Arrested
FIR.
and produced 18/7. 18/7. Then 21. Okay, yes.
The main challenge is that no offense at all matters. As
Yeah.
alleged, suppose he stolen property, FIR is filed alleging that that is stolen property.
Are you
But-
still in jail?
No,
Huh?
I purchased it with valid purchase document. I have annexed all that. And nothing has been complained, no one has been compelled that these are the stolen theft article. There is nothing that the petitioner has ever been
Because,
involved. in.
Mr. Fukon, we cannot take documents outside it. We have to read the complaint as of now, right? These documents may be very genuine. Why don't you place it before the IO
It is
for
police-
examination?
Police has already examined. and
These
it is
documents.
Seize the document. It says all. seize the
Okay,
document.
then, Mister, if it is genuine, then it may be. And you were caught inside Assam,
Inside Assam.
inside Assam, meant for Nagaland, but not in Nagaland.
Not in Nagaland.
Till they crosses the border of Nagaland. Nagaland is a dry state.
Yes, ma'am. Fresh.
But if these are purchased with this kind of invoice,
My lord, at
a
this
case may
moment,
not be, but yeah, stamps, seals are there, I don't know.
my lord, because here Excise Act is also there.
Excited, not violation, no violation.
What excise?
Excited that if we have to valid.
I
that
think
fund,
police has registered a
for
case.
procuring.
Under Excise,
So let him examine this. If you have submitted all the documents, let him give a report
yes, ma'am, report. ma'am. Yes, at least report may be called for.
that this performer invoice and all, right?
Yes.
Had Mr. B. Fukon, land counsel for the petitioners, and Mr. R. Kosik, land additional public prosecutor for the respondent number 1, State of Assam. Poster. The 3 petitioners have preferred the instant given petition under section 528 BNSS, seeking passing of a first information report registered as Hiladhari Police Station case number 02/2024 for the offenses under এই পেজ 20 ভালকে লিখা আছে পেজ 20 রেফারেন্সত ভালকে লিখা আছে FIR was registered after interception of a large KK of CAC Ichi liquor cartoons on 17/7/2024 from a truck.
Proceed. Kindly peruse page 30.
Yes,
The vehicle number
yes, 30.
initially.
Hmm.
AS01 EC 0035.
Okay, 0035.
And the vehicle which has been intercepted, number is different. ma'am.
Oh,
One
yeah,
bullet.
that's from a truck. From a truck. From a vehicle bearing registration number AS03/BC -7030, which was proceeding from Morini side towards Nagaland. Poster. The KK of liquor cartons were seized on the suspicion that those were illegally transporting to Nagaland, violating excise rules. Poster. A total of 8 accused persons were apprehended, and the 3 petitioners herein were among them. Full stop. Subsequently, the petitions were released on bail. Full stop. The contention advanced on behalf of the petitioners is that the petitioners had valid document as regards the KK of liquor cartons so seized on 17/7/2024, and the documents have already been submitted before the IO of the case.
For the IO has in fact seized the
Post of, it is further submitted that the documents have been seized by the IO of the case. Post of, it is contended that from the documents, it would be expressly evident that there was no illegal transportation of liquor. Post of, the petitions have relied on the documents annexed to this petition as annexer 4 to annexer on annexer 4
and 5.
and annexer 5. Post of, well, issue notice returnable in 4 weeks. As Mr. So-and-so is appeared, accepted. That's my number 1. No formal notice. Extra copy within 2 days from today. The additional public prosecutors is to obtain a report from the IO of the case regarding progress made in the investigation and also a post-op and also about the documents submitted by the petitioner in support of transporting the take of liquor cartoons on 17/7/2024.
Item number 14.
Other time.
Item 16.
Yes. The dispute between my lord son-in-law and my father-in-law. And my lord, the purely my lord civil lesser case, 138 of by night is there. It's take bullet destroyed. Let us see the complaint first. Complaint. Page my lord 13. Page 13. Gogoi. Yes, take a loan from the complainant my lord 7 lakhs my lord. And regarding that issue, she's now. Sumitra Setia is man or male or female? Not female. Female. He's a mother-in-law, man. Complainant. Gohin Gogoi. Gohin Gogoi is what? Gohin Gogoi is a son-in-law. Son-in-law. You were saying that page 13, this Gohin Gogoi is the son-in-law of the accused. Accused. Son-in-law of the accused. Son-in-law. Let us see what kind of allegation. You are not in good terms or what?
My lord, kindly say, look at my lord.
No, you are not in good terms.
Now, my lord, I am retired, my lord, just after retirement, my lord,
Hmm?
January, my lord, I retired, my lord, February, see, my lord, he deposited one of the segment. And after that, my lord, I closed them. Even, my lord, kindly have a look, my lord, only. The loan, according to complaint, my lord, loan was taken on August 2023, my lord. And kindly have a look, my lord, page 22, my lord, the annexure C. The complainant has already taken a loan, my lord, more than my 24 lakhs, my lord. And my notice was issued to me, my lord, as a guarantor. I was the guarantor, my lord. And my lord, regarding that loan, my lord, my bank has also been seized, my lord, for some time now. Page, my lord, 22 and 25, my lord. Page 20, my lord, is the, my lord, notice, my lord, under section 60 of
So
the.
did you did you say all those things before the court?
No, no, this is my evidence only.
Oh, no, page 21.
Page 22, my lord.
Page 21.
Page 20.
Did you say so? Both the complainant and the accused person present.
My lord. But that was.
All those things.
But that was not.
You did not say those. No objection file written.
Maybe, my lord. Even after.
Everybody comes to this court without doing anything before the trial court. Very difficult.
T1, 8 Mala, T1, 8 Mala, T1.
Right, but before running to this court, you should have.
I was the guarantor, my lord.
No, you should have placed all these materials before the trial court. That is what I am saying. Hard, Mr. Econicor. Learn counsel for the petition. The instant criminal petition. Under 528. Or Bharatiya Nagori Kuraka Honita 2023 is preferred. Seeking. Setting aside of criminal proceedings pertaining to complaint case number CR 19/2024. Presently pending before the court of CR case number 19 of 2020. Presently pending before the court of Janet. Judicial Magistrate, First Class Dhokwa within bracket trial court. And an order dated 24/7/2025, whereby the learned trial court has framed charges under section 318 within bracket 3/318 within bracket 4 of the Bharatiya Nyaya Honita. Post para. It is contended on behalf of the petitioner that a plain reading of the allegations made in the complaint within bracket annexer A would reveal that the ingredients of the offenses under section so and so strokes sections 3183 are apparently missing, and as such the learned trial court has erred to observe that there were sufficient materials to proceed against the petitioner for those offenses. First up, it is further highlighted that the petitioner, who is the mother-in-law of the complainant, stood as a guarantor to the complainant when the complainant availed credit facilities from Punjab National Bank for his dealership enterprises, as is evident, as are evident from NXRC document, post of issue notice returnable in 4 weeks, as the petitioner shall take steps for service of notice upon the respondent by registered post with AD as well as by usual process. Post of upon perusal of the allegations made in the complaint, it can be noticed that the petitioner had allegedly issued 3 checks to the complainant for a total amount of rupees 7,50,000. And the complainant had alleged that the said amount was advanced by him as loan. Post of it is further revealed from the complaint that the complainant had acknowledged to have received an amount of rupees 3 lakh out of the said loan amount of rupees 7,50,000. Post of there was an allegation that one check was degenerate on presentation at the instruction of the petition. Post of having regard to the contents of the complaint and the positions made on behalf of the petitioner, it is ordered in the interim that further proceedings of so-and-so case number presently pending before the so-and-so shall remain suspended. There is unable to. Just scan copies of case record so-and-so be called for.
Item number 17.
May I please, your lordship? Lordship, a criminal petition 528 read with section 14 of the Family Courts Act, your lordship. The impugned order is at page number 17, your lord.
Final order.
Indeed, your lordship. Final order at page number 17, your lord. From page number 17.
10,000, 5 plus 5.
5 plus 5.
Position of this.
Your lordship, may I submit one simple fact, your lordship? Thereafter the marriage, there was a mutual agreement of divorce wherein she took around 2,50,000. Thereafter, immediately before coming to this court, on last month, we paid an amount of rupees 1 lakh. There is a criminal execution petition pending before us till the time of the notice that may be scheduled. We have paid an amount before approaching this one. So the payment is at page number 66, your lordship, on last 11th of July, your lord. Just for 1 month, he is in. The only issue is that the assets and liabilities were not taken by the, was not submitted.
Will only simply issue notice.
Indeed.
People are running here for 2,000, 3,000, 4,000 maintenance amount, seeking stay interference. This is to be for a minor daughter. Father is neglecting to pay. No. Mr.
TL Oscar, your lord.
TL Oscar, Land Council for the petition. The petition is assailing order. The judgment dated 10/5/2024 passed by the Court of Lanet. Principal Justice, Family Court number 3, Kamrup Metro, Guwahati, in FC criminal case number 694/2019, whereby the Family Court has directed the petitioner to pay an amount of rupees 10,000 per month, that is, rupees 5,000 each to the respondents herein and the daughter till she attains majority as maintenance amount with effect from 25/11/2009, petition of this returnable in 4 weeks. Case records of so-and-so be called for. Scan copy of the case records of so-and-so be called for. The petition shall take steps for service of notice. Upon the respondent number, oh sorry, RR Kosik Kidu, respondent number 1, respondent number 2, by registered post lady as well as by usual process during CHIO in this complaint. The prayer for interim leave is kept open for consideration on the return and date. Much obliged.
Item number 18.
Please, Your Lord. The petitioner, Your Lordship, by way of the present petition, Your Lordship, has challenged a proceeding in a complaint case, which cognizance has been taken, Your Lordship, and petitioner has also appeared before the learned court.
What is the complaint?
Complaint, Your Lordship, will get it at page, it starts from page 20, Your Lordship. Your Lordship will page 23 onwards, Your Lordship, the operative.
Yes.
May I read, Your Lordship? From 3 onwards, Your Lordship. Para 3 on. That all accused persons have been in illegal business of money lending against commercial interest for many years. They used to give commercial loan to different persons and charge the rate of interest from different customers. The money lending business is illegal as they do not possess any valid license for lending money to the people, which is required by law as laid down in section 3. And by virtue of their friendly relations during the period 2020-22, the accused person 3 and 4, with the help of other accused persons, insisted the complainant to take financial assistance as loan from them, Your Lordship. The accused persons even assured to sanction loans for the complainant from their self-help group or from their financial institution, thereby they induced the complainant to submit her application biodata along with relevant documents such as bank details, signed check, and bank non-judicial and some papers containing her signature. Being convinced with the proposal of the accused person, complainant submitted her application biodata and signed up 10 number of from her savings bank account number maintained with the State Bank of India and with non-judicial stamp paper, etc. Accused Deji Pathak, wife of Dipankar Mes, obtaining a loan. That after a few days of submission of the aforesaid documents, the accused person informed that the self-help group as well as the state bank refused to sanction the personal loan to the complainant. However, the accused let the complainant know that they can help her by giving monetary loan by virtue of their friend relation, as they are already in the business of money lending. The accused person number 3, similarly Deji Pathak, and accused person number 4, Dipankar Mes, very deceitfully kept all the documents, signed up checks and signed up blank judicial stamp papers in their hand, which were already submitted by the complainant along with her loan application for obtaining loan from bank, financial institution to the accused person. That on 8/2/2020, complainant has taken a loan of rupees 20,000 only from the accused Bhairavi Gohai Moran against monthly interest of 10%, which was repaid by complainant along with interest as demanded by this. After clearing the said loan, transaction continued between them, and as the complainant took approximately rupees 150 lakhs only from the state Bhairavi Mohan as loan on monthly interest. The complainant returned the complete loan amount to the said Bhairavi Gohai Moran on different occasions in different modes such as cash, bank transaction, Google Pay, etc. It would be relevant to mention herein that out of the said transaction, the complainant paid rupees 50,000 only in the Google Pay number of the husband of the accused Bhairavi Gohai Moran, namely Simanta Moran. The complainant also paid the money in the accused in the mother-in-law said Bhairavi Gohai Moran on number of occasions. Complainant has paid more than 11 lakhs only to the accused Bhairavi Gohai Moran until today against the date of 150. Only but surprisingly enough, the accused Bhairavi Gohai Moran and her husband, accused Simanta Moran, never found satisfied with that and always has been asking for more money from the complaint. And it is pertinent to mention herein that accused Simanta Moran, who is also husband of the Bhairavi Gohai Moran, played a crucial and active role in this extortion process, as he on many occasions himself used to collect the monthly interest from the complainant and also used to threaten the complainant with dire consequences in the event of any lapse of delay in paying the monthly interest to them. Then in the year 2020, complainant 2,000 only from the accused Deji Pathak per month. It again took an amount of
tax from said accused person, 13% interest per month. She again taken another amount of rupees 1 lakh only from the AG Pathak on monthly interest and 13% month which she actually arranged from one government officer, Mohendra Paul, and so Mohendra Paul gave this amount to the AG on monthly interest of 10% per month. Accused AG Pathak and accused Dipankar Mas have been extorting monthly interest against these loans amount from complete regularly and up to month June 2023, and thus the complainant has already paid more than rupees 13,23,000 only to the accused Daisy Pathak and her husband Dipankar Mas. It is pertinent to mention herein that husband of Daisy Pathak, Dipankar Mas, used to collect the monthly interest from the complainant residents every month, and in the event of any delay in paying the interest, he used to threaten the complainant face with dire consequences, physical assault, the image of reputation of her entire family to snatch the property of complainant, etc. That lastly on 25/7/2022, Dipankar Mas has forcefully extorted an amount of so and so from the complainant, her residence situated Kakapathar as monthly interest. Dipankar Mas even visited the residence of the complainant's parents, Pinghong Moran, under Dibrugarh district to collect monthly interest and threatened the complainant and her family member there. Then in the same event, year 2020, the complainant took an amount of 50,000 only from the accused Srimati Sarjini Bora Moran, wife of Bhairav Moran, at 10% per month. The complainant already returned the said amount to Sarjini Bora Moran along with interest with December 22, but the accused Sarjini husband Bhairav extorted more than rupees 4 lakhs only from the complainant in the name of loan monthly interest till 26/2023. The accused Bhairav Moran is very aggressive in nature, who used to threaten the complainant to damage her physically as well as socially if she doesn't to pay interest as per their demand. The complainant has duly refunded the entire loan amount to all the accused persons along with interest at them within the agreed time period. It is relevant to mention here that accused person extorted a huge amount of money from the complainant in the name of monthly interest and loan repayment. This person never returned her signed blank check and signed up non-judicial papers till today. But however, after repeated demands and requests, the accused persons always shows that loan yet not liquidated from the complainant, other if they demanded a huge amount of money from the complainant, non-payment of the same along with its interest, and as a result, same difference is going on in between parties, that is complainant and accused persons. As a consequence of the same, accused persons and their agents frequently visits the residence of the complainants in the name of recovery of their dues, and complainant and their agents threaten complainant and her family by showing their masculine manpower. That as complainant showed her inability to meet the illegal demands of the accused person started to demand and threaten the complainant to hand over them if vacant possession of her landed property and house premises in state locality, otherwise to face with dire consequence. It is pertinent to mention that accused persons as well as their family break touch with local organizations such as Moran Students Union and other local pressure groups, as well as with some unsocial elements in their locality. As such, they always try to dominate the people who are not origins of the locality. On the other hand, the complainant and her family are newcomers to the locality as they just started to live there after purchasing a landed property there.
Mr. Borogo, it is after 202,
Yes,
after
Your Lordship, it is
examination
there,
of 6.
Lordship.
Yes.
My point is this, Your Lordship. This is the case Your Lordship has seen, Your Lordship. While he says what has in fact happened, Your Lordship, she has collected around 85 lakhs rupees from these people, Your Lordship. And after that, Your Lordship, he has virtually, she has refused to pay the money, Your Lordship. That's why, Your Lordship, that this has come as a counter blast, and Your Lordship will kindly have to pay 70, Your Lordship, for a moment. This was a, Your Lordship, not only from these 5 persons, Your Lordship. This was a notice by the circle officer, Your Lordship. Then when we complain it before the circle officer that this has been happening, and Your Lordship will kindly note the date 22/9/2023, and Your Lordship will find then they were asked to be there, Your Lordship, in the office of the circle officer, so the dispute can be, Your Lordship, considered, Your Lordship. That day, had there been a, Your Lordship,
Where from this circle officer is having jurisdiction to
no, Your
decide?
Lordship, we have, Your Lordship, represented before them, Your Lordship.
Is he a judicial
No,
authority?
that is not there, Your Lordship, to show that, Your Lordship, that is to show that we have not taken law into ourselves, Your Lordship. And Your Lordship, it is a case. My point is this, Your Lordship, we are not averse to, Your Lordship, this, Your Lordship, investigation. My point is, this is a case, Your Lordship, where seizure will be required, Your Lordship,
interrogation of the accused persons and others will be required, Your Lordship. This was a case where the learned trial magistrate, Your Lordship, ought to have, Your Lordship, exercise either power under 156(3) or 202, Your Lordship, Your Lordship, seeking a report from the police, Your Lordship. Without doing that, Your Lordship, this is a completely an abuse of the process, Your Lordship. Your Lordship has seen, she says that I have refunded the money, but not a single piece of evidence, Your Lordship, to show that she has refunded the money, Your Lordship. Simply based on certain allegations,
When
Your
it was
Lordship.
instituted,
This-
2023.
Lordship. And Your Lordship will kindly see these statements under 202, Your Lordship. It should have been, Your Lordship. In 202, Your Lordship, no case under 387 made out, Your Lordship.
What is 387?
Your Lordship, extortion, Your Lordship. There is no threat to life, Your Lordship. There will have to be some material, Your Lordship, based on which, Your Lordship, the court will take cognizance, Your Lordship. That material is absent, Your Lordship, in my humble submission. And if Your Lordship go through this statement, CW statement, Your Lordship will find, Your Lordship, that these materials are not present, Your Lordship. It is purely a civil dispute, Your Lordship. To, Your Lordship, avoid, Your Lordship,
No.
repayment, Your Lordship,
First,
ultimately she has come up with this
Mr.
plea.
Bhottakur, we need to have a privacy reading of the complaint only,
Lordship,
right?
Lordship,
Not going behind what is
Lordship.
going on, who is the money lender, who is not,
Lordship,
for seeking,
Lord-
quashing a privacy reading of the complaint plus all the statements,
Lordship.
right? And it has to be a good one, so we can examine, but I don't know from reading who is the money lender, who is the victim.
Lordship,
I am not, whether Mr. Bhottakur is the money lender or the
Lordship,
lady is the money, I am not.
And Your Lordship will
We have
kindly
to
see
examine in detail,
cognizance is not taken under Money Lending Act, Your Lordship.
right?
Lordship.
But there are criminal intimidation, all these are there.
Lord,
The statement,
Lordship.
you know the parameters.
Lordship, I know.
Mr.
Your
Bhottakur,
Lordship, I
you know the parameters.
Lordship, I know, Your Lordship. What has fallen from Your Lordship's mouth, but Your Lordship, here.
The complaint is to be read,
Lordship,
no external document,
Lordship,
right?
Lordship,
These are, you have said right, the
Lordship,
ADC or circle officer,
Lordship,
another proceeding is
Lordship.
for him. He is also an authority, he does not have judicial function.
Lordship, that is there.
You ought to have initiated an investigation.
That, Your Lordship, we have, Your Lordship. We have an
That is not-
ZD entry was.
If you are victim, you should have initiated it.
No, Your Lordship, we have, Your Lordship, laws and register, ZD entry was done and investigation is going on. That's why, Your Lordship,
Preliminary perhaps.
Lordship, and
Perhaps.
Lordship.
Because I am also confused. Who
Yeah.
is the victim? Who is the money lender?
Lordship, and that,
Bhottakur. From my reading, I have just read, I cannot read so many things
Lordship,
for 12, 13 pages for
Lords,
sitting in a court. But looking at there are some, here's maybe a clever drafting.
Lordship, it's a
piece
clever
of
drafting,
clever
no doubt
drafting.
about
We
that.
don't know.
Lordship,
Piece of clever drafting it can be.
Lordship,
Perhaps as seasoned as Mr. Bhottakur
Lordship.
is behind drafting of this petition also. We'll issue notice at this.
Lordship,
Let the lady come.
Lordship.
Heard Mr. S. Bhottakur. Let her come for the petition. Will you call for the scan copy also?
Lords.
The petitioners have instituted, have filed this criminal petition under section 528, seeking quashing of the proceedings of complaint case number 100 stroke 2023, presently pending before the court of subdivisional judicial magistrate as in Sukia trial court. And an order dated 27/1/2025, whereby the land trial court, by taking cognizance of the offences under section 120B 387/506 34 IPC, issued process against the petition for their appearance. Post of Mr. Botagul and counsel for the petitioners has submitted that the ingredients of the offense under section 387 IPC are missing, are found to be missing on a simple reading of the complaint as well as the statements of the witnesses recorded under section 200 and 202 TRPC. The matter would require further consideration. The scanned copies of case records of offense will be called for to notice the petitioner's returnable date for the petitioner shall take stage for service of notice of the respondent number respondent registered post UDD. The prayer for entering relief will be is kept open for consideration on the returnable after perusal of the matrix. 506 is not there, but otherwise maybe 387 may not be there. We are confused. Who is the
Victim.
19-9.
come back?
Supplementary list, item number 38.
May I please, Your Lordship? In this case, Your Lordship, the Zimmer petition has been allowed by the learned court below, subject to file furnishing bank guarantee, Your
Which
Lordship.
one to? Which guarantee? Bank guarantee? Huh? No, Jima. Yes, Mr.
Lordship, operative part at page 19, Your Lordship.
My lord, last time I took time to go through the
No.
judgment, my lord. Passed by Honorable
This,
Justice.
I think this is the judgment.
Yes, my lord, Mujibur Rahman.
Huh? 1 minute, Mujibur or not Mujibur. Joharuddin.
My lord.
Reaction line, criminal petition 509 2024.
This is passed by just AD
Or
Chaudhary.
AD Chaudhary.
Yes, this is also same, my Mujibur
This is the main original.
509. Joharuddin, my. Same proposition as
I have not read.
Same proposition has been
This is the main one.
main one, mine. Well, in fact, same day it has been passed.
Same day. Which one?
Both, my lord, and Muhammad Joharuddin
Huh?
and the date of judgment is
Mujibur Rahman.
and Mujibur Rahman.
Okay.
Maybe both were connected or maybe they were taken together, my lord.
Okay, okay. This cattle preservation.
Cattle preservation.
1 minute, let me read. This is regarding what seizure of custody of what?
Cattle, your lordship. In our case, your lordship, vehicle and 4 numbers of mobile.
Hmm?
In our case, your lordship,
Hmm.
the Zimma petition was filed for custody of Zimma, 4 numbers of mobile and 1
I mean,
four-wheeler and 2 motorcycle. That has been allowed by the Lanet Court, subject to furnishing the bank grant.
bank guarantee.
Yes, your lord, which is equal to value of the article, your lord, this article. Being the petitioner is belongs to below poverty line and justice scheduled type community, they have unable to manage the bank guarantee. Therefore, in spite of receipt of order one.
No, Mr. Kosik, has this judgment dealt with bank guarantee?
Yes, and in Mojibur case, basically pertaining to cattle, your lord.
Mojibur case pertaining to cattle mine.
Cattle, but it is different. I have earlier, yesterday submitted some judgment passed by coordinate branch, your lordship. Here,
Which
similar
one?
situated.
And this Joharuddin is vehicle.
Hmm? Joharuddin,
Joharuddin is vehicle, right?
vehicle.
Vehicle. And Joharuddin to Tumar 50. Tour আছে এটা এইটো কেটেল হয় এইটো কেটেল নাই এইটো পইটো লৈ যাওক
CAV 143. 140.
24.
Yes, bank guarantee
Okay.
heard Mr. S.I. Akant, Planet Council.
In fact, Mujibur Rahman is the main judgment. It seems, my lord.
After Zohruddin,
Same day, it has been passed.
same day,
But the Mujibur Rahman, it was more, my lord, categorical discussion.
S.I. Akant, Planet Council for the petitioners, and Mr. R.R. Kosik, Planet Additional Public Prosecutor for the respondent state. Full stop. The present criminal revision petition under section 538 and section 442 read with section 528 of the Bharatiya Nagorik Suraksha Honita is preferred, has been preferred, seeking modification of a part of an order dated 1/7/2025, passed by the Court of Planet Sessions Judge Kokrajar in Sessions case number P2/75/2025, which arose out of ZR case number 163 of 2024 and PRC number 218 of 2025. Full stop. Para. On 27/3/2025, a sub-inspector of police in charge Patgaon outpost under Serfanguri police station lodged the first information report before the officer in charge Serfanguri police station in reference to a general diary entry, ZD entry number 894, in reference to two general diary entries, ZD entry number 394 dated 26/3/2025 and ZD entry number 399 dated 27/3/2025. Full stop. As per the affair, based on information received, one vehicle within bracket Mahindra Supro maxi truck, no, three vehicles, PS 15 আছে 1 2 3 করে দিব, were intercepted at an area in Patgaon. After search and seizure from subject vehicle number 1. 6 number of kettles. Within bracket bull were recovered in presence of independent witnesses. The driver and the handyman of the subject vehicle number 1 could not produce a valid document as regards transportation of the kettles. Full stop. They stated that the driver of the subject vehicle, comma, number 2, and the rider of the subject vehicle number 3 were the owners of the seized cattle. Full stop. All of them were interrogated and apprehended. Suspecting them to be involved in the smuggling of cattle for slaughtering purposes. Full stop. The affair has been registered as Sairfanguri Police Station, case number 12/2025, under sections 303 within bracket 2 stroke 3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023 BNSS, read with section 11 within bracket 1, Prevention of Cruelty to Animals Act 1968, Niki, read with section 13 within bracket 1 stroke 14 of the Assam Cattle Preservation Act, comma 2021. Full stop. The investigation ensued thereafter, and after completing investigation, comma, the IO of the case submitted a charge sheet, pursuant to which the case stood committed to the Court of Sessions, Kokrajhar. Post of on being committed, the case has been registered as session case number T2/75/2025. Post of para. The petitioner saying who were apprehended on 27/3/2025 in connection with Sairfanguri Police Station case number 12/2025, comma, preferred an application before the trial court seeking interim custody of the following articles, comma, which were seized from them during the course of investigation. Page 80 note, 1, 2, 3, 4, 5, 1, 2, 3, 4, 5. Five, 6. Para. The order dated 1/7/2025 has been passed by the trial court after hearing the learned counsel for the petitioners and the learned public prosecutor on the prayer for interim custody made by the petitioners with petition number 2168/2025, petition number 3166/2025, petition number 2162/2025, and petition number 2164/2025. Poster. Para the trial court took into consideration that keeping the seized article would not serve any purpose, and the seized items were required for day-to-day use by the petitioners. Poster. The interim custody of the seized article, the trial court was of the further view that the seized article, interim custody of the seized article can be allowed to the petitioners, subject to the condition that they should produce those articles as and when required by the court. Poster. The trial court was of the further view that there was nothing on record that the trial of the case would be hampered if the interim custody of the seized articles were allowed to the petitioners. Poster. Accordingly, the interim custody petitions, aforequoted four interim custody petitions were allowed. Poster. By the order dated 1/7/2025, the eye of the case was directed to give interim custody of the seized article to the owners on execution of bank guarantees, and after verifying the authenticity of the ownerships. Poster. The operative parts of the order dated 1/7/2025, in respect of which modification has been sought for, read as under page 19, A to A. Para. It is the contention of the petitioners that the condition imposed by the trial court regarding furnishing of bank guarantees against the seized article, is not easy, and in fact, onerous and harsh. Full stop. para. The well, para like cattle preservation. It is contended that the condition of bank guarantee has been, condition of furnishing bank guarantee has been imposed perhaps for the provisions contained in subsection 5 of section 11 of the Assam Cattle Preservation Act, 2021. Post of. A coordinate manner of this court in a judgment, an order within by CAB dated 22/05/2024, passed in criminal revision petition number 143 of 2024, has laid down the following propositions of law. A what was short করে দিছে Act 2021 এইখন আগতে short কৰি দিব বুঝছে In the case in hand, comma, six number of cattle, within bracket bull, were seized from subject vehicle number 1. Post of. The present petition relates to the aforestated 6 articles, seized article. And condition imposed regarding furnishing of bank guarantee to facilitate interim custody to the petitioners. Post of. The IO of the case has already submitted the charge sheet after investigation. Also, furnishing guarantee equivalent to market value of the seized article. Para. In view of the determination made in criminal revision petition number 143 stroke 2024 by the coordinate bench by the determination. It is making determination by the coordinate bench, it has been observed that when an application for interim custody is filed after the charge sheet was laid, the consideration of grant of interim custody cannot be said to be an exercise of power under subsection 5 of section 11 of the Assam Cattle Preservation Act, and therefore, the insistence of bank guarantees as prescribed under subsection 5 of section 11 of the said act shall not be applicable. In view of such determination, this court is of the view that the part of the order dated 1/7/2025 supra, whereby the learned trial court has insisted for bank guarantee for amounts, mentioned therein, is not sustainable under the law, inasmuch as at the time of filing the interim custody applications, the investigation was already concluded. In view of the above, the present petition is allowed by setting aside that part of the order dated 1/7/2025, whereby furnishing of bank guarantees for the amounts mentioned in the extracted portion of the order above, was insisted by the learned trial court. As a consequence, it is directed that the interim custody of the six seized articles, mentioned above, be granted to the petitioners on the following terms and conditions. Move order after that. Who is the owner of that vehicle?
Petitioner number 3.
So the investigating officer shall prepare proper panchnamas for the mobile phones and subject vehicle number subject vehicle number so and so. The vehicle bearing registration number so and so. And such get the signatures of the owners or registered representative of the owner after submission of an indemnity bond each against the seized article stroke vehicle for the amount quoted by the learned trial court. By Hindi, the owner of the vehicle number so and so shall not change the color or structure of the vehicle and shall not also dispose of the vehicle till disposal of the case. Similarly, mobile phone. RO. Last, the petitioners stroke owners in whose favor the interim custody of the above 6 articles stroke vehicle have been granted shall produce before IO, shall produce the same before the IO or the concerned authority as and when called for the purpose of call for any call for the purpose of the trial. The criminal petition is disposed of, revision petition is disposed of in the appropriate terms.
সব বলাইছে
মোৰ এটা আছে এইটো নালাগে
Time being matters. Item 10.
Lord, you've seen the provision, my lord, actually pre-issued as your lordship is correct, my lord.
Because you have a good case,
Yes.
but you have to fight it out first at there. If you fail there, then you come.
But only, I pray, only one observation, that earlier 2 FIR was lost on the same cause of action and same.
Had
date
you
of-
asked that, we will not jump that because we are not, you, first, have you received instruction that whether they have appeared there?
No,
Heard
they have not
Mr.
appeared.
A. Ali, learned counsel for the petitioners, and Mr. MP Goswami, learned additional public prosecutor for the respondent. Number 1, State of Assam. The instant criminal petition under section 528, Bharatiya Nagorik Surakha Honita, is preferred, setting aside and stroke or quashing of the proceedings of a complaint case, registered and numbered as CR case number 178/2025 before the Court of Learned Judicial Magistrate Dorong at Mongoldoy. Post of para. The petitioners have approached this court after issuance of a notice from the trial court. Do you have a copy of this? No. Page 75 notice from the trial court,
Yes, my lord.
whereby they have been informed that the complainant named Rameshwar Deka and Salau Rahman complainants have filed the complaint before the trial court, and the said complaint has been admitted for hearing. Full stop. By the notice, the petitioners have been asked to appear before the trial court, personally or through their engaged advocate. Full stop. Para. On a query made to the learned counsel for the petitioners, it is submitted that the trial court has not yet taken cognizance of on the complaint full stop. Para. As per the first proviso to subsection 1 of section 223 of the BNSS, no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. Full stop. The magistrate having jurisdiction as per subsection 1, the magistrate having jurisdiction while taking cognizance of an offense on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing. Full stop. Para. This court, as this court has found that the notice sent to the petitioners is under the first proviso to subsection 1 of section 223 of the BNSS, the petitioners have not yet availed the opportunity of being heard provided therein. Full stop. In such view of the matter, this court is of the considered view that the petitioner shall first exhaust the remedy of opportunity of being heard provided by the first proviso to subsection 1 of section 223 of the BESS before approaching this court. Full stop. The liberty stands reserved to the petitioners to avail appropriate remedy if they find themselves aggrieved by any order passed by the trial court after hearing them. For the aforesaid region and for aforesaid region, the criminal petition is not entertained at this stage. Not entertaining. I'm not dismissing or closing.
Obliged, Lordship. Item 11.
You are on the same footing.
Lordship.
Let us see order taking.
Is agreement.
Which order?
Section to research.
Accused are absent, citing cause of illness. Who has paid to send the case record. What is the background?
Complaint filed by one Fakar alleging that one Islamuddin, introducing himself as a tractor dealer, lordship, assured them that they parents to,
Oh, no, this is a page 19 is the complaint.
yes, lordship.
Page
Page
19 is the
16
complaint.
Page 16 is the type copy.
Hmm?
Page 16 is.
Okay, page 19 is the complaint. Then what happened?
Lordship, there is allegation is that the petitioner is the branch manager of Jagita.
No, then what happened? I am not entering into the contention. Then after that, what happened?
After
Case has been raised, complaint has been registered as CR 920 stroke 2024, right?
the stage of-
Thereafter?
At the stage of appearance, the person.
No, you are not
Because-
understanding my point. Yes, Mr. Buston.
Lordship, it was
Well, let me look at myself then.
some objectives are directed for the seconds.
Now, after this complaint case, 1 minute.
And para of 30. Okay.
Say case along together,
Lordship,
namely
there-
Islamuddin and Mithu.
Already, FIR is lordship, and going. And as the order. of-
Oh, the complaint was also low. No. Fakhruddin lodged the complaint. So there is difference between FIR and complaint. So be sure about the word. Fakhruddin lodged complaint, page 19, where you were accused number 1 and Islamuddin Mithu Bora, right? State case was placed before the SDGM for disposal. Accused. It was alleged in the introduced so and so whatever, and they have so and so on bona fide belief. Number told the complaint witness to meet the manager. They have shared so and so, so and so. Notices were sent to you
Yes, lordship.
in complaint. Where is that?
That.
Under 223.
Sector
Ah.
A lot is 13.
Page
Page 13.
13. Okay, these are notice. Page 13. Appear.
Already
Okay, you appeared.
Yeah.
Then what happened? 5/10/2024.
already
Okay.
appointed,
Then
and
in the meantime, FIR lost by chief manager.
another FIR was
Another FIR.
by Punjab
That has been registered as Zagirot Police Station case number 7/2025 under section 420, 409, 468. That was registered on 30/12/2024. And your notice was when? This page 13 notice,
15
October. Then you approached, got bail
Yes. Anticipated will.
in police case. Then you appeared in a complaint case, right? And entered in, and that court directed
And 26.
investigation under 175(3).
25 was also the date for appearance, lordship. Right. And on.
No, 170, that is the impugn order perhaps.
Page 33.
No. 26.
Page 36. also
26.
For appearance. 26.
Now, what is your submission?
Commission Lordship already FIR filed on the same party, same offense. Then FIR cannot register.
Yes. Plus. Complaint was not examined.
No.
And without even hearing the
Then,
Inshallah.
considering the alleged offense, observing the material, I deem it proper police investigation. If it is a complaint,
Complaint.
then that it was not preceded by any
No.
earlier FIR,
No.
right? To the officer in charge
No.
and SP.
Yes.
So this is not that 156.3.
Yes. No. This is
If it is,
it is independent. My first FIR, first FIR.
There is an FIR
No.
by another authority,
Right.
but regarding the same transaction,
Same.
right? And this complaint is directly made
Directly made.
without being preceded by, there is no allegation that
No.
I lost the FIR, it
No.
was not registered,
Not
approached the SP,
Nothing.
then affidavit.
No.
Right? Now, let us see 175.
Yes.
We'll see at 2. MSDB will see that.
our contention is since an FIR has already been registered and on the same state of facts, same offense, but it second FIR is and also the criminal the complaint case was the stage of clearance law. And without hearing the party.
Was it brought to the notice of the court? It is not reflected.
Not reflected.
You were present.
Is present.
It's not present, Lordship, but.
No, accused was present. This petitioner was present with steps.
Accused amongst his
Absent with steps, but your counsel was present.
present.
It is as good as your presence.
Of their counsel.
It was not brought to your notice.
That part there. Yes.
The notice of the court.
Yes.
How can the court know? Otherwise, the court could have exercised the power under section 210
Yes.
to stay the proceeding of the complaint case.
Yes.
Complaint case was not that case of the that FIR is. Was not the.
That is Ms. Devi, that is exactly why now the provisions of 223 has been incorporated. You could have brought it to the notice of the court that yes, investigation is pending on the almost similar set of facts.
Otherwise, my order is not very perverse, madam, since the 2-6.
Yes, because he was present.
He was present.
He was quite aware
Yes.
about
and
the investigation of other cases.
Investigation is some investigation is required. That is why he is referred to the police because it cannot be done through 223. That is, reason has also been given, madam. That is one part, madam. But there
Let this
two
man
efforts are
come.
there. That is different, madam.
Well, issue notice, let this man come, complainant. It should be passed, he should justify why should his complaint should. And what is the, otherwise, what is the illegality in the order?
First of all, the one case is FIR is already pending. Second is lots.
What is the corresponding provision of 202?
That's it.
What is the corresponding provision of 202? 225.
Fairness.
202 and 182 is there, my lord, here.
Something is wrong. One 175.3. Any magistrate empowered under section 210. 210. Any magistrate. One 173.4. One 173.4. Three. Complaint. After considering an application supported by an affidavit. Yes, Mr. Goswami, 175.3.
BNS,
BNS.
BNS.
Any magistrate
Magistrate.
empowered under section 210.
And after.
That is
consider-
taking cognizance,
Lord,
either on complaint
either
or police report,
police report.
right?
Right.
On receipt of information relating to commission of any cognizable offense, which is made punishable, sorry. After considering an application supported by an affidavit made under subsection 4 of section
173.
73. This is the requirement.
Yes,
Now come to 173.4.
any person aggrieved by refusal.
Where is the refusal?
Of the part of the officer. They have not approached.
So there
That
cannot
is-
be 175.3.
Three.
He has exercised
Yes. That is
this
why-
power.
Yes,
Something is wrong.
Lord.
Heard Miss RDB Learning Council for the petitioner. And Mr. MP Goswami and additional public prosecutor for the respondent state. Respondent number 1, state. From a state of Assam. The instant criminal petition under section 528. Bharatiya Nagorik Purikha Anita 2023. Is preferred. Seeking, setting aside and quashing of an order dated 2/6/2025 passed by the Court of Learned Subdivisional Judicial Magistrate Hodor Morigaon in complaint case number CR 920/2024 and the entire proceedings of complaint case number 920/2024 poster. The SLE is made primarily on 2 grounds. Firstly, an investigation for the same set of facts and allegations are being undertaken in Zagi Road Police Station case number 7/2025. Registered under sections 120 capital B stroke 420
Complaint.
stroke 409
Complaint.
stroke 468 Indian Penal Code. And secondly, by the order dated 2/6/2025, the Learned Trial Court forwarded the complaint filed by the respondent number 2 before it to the officer in charge, Zagi Road Police Station, for registering a case under appropriate sections of law, conduct proper investigation and to conduct proper investigation and to submit a report in final form at the earliest. Full stop. The power is purportedly exercised under section 175 within bracket 3, BNSS. Full stop. It is contended that the power under section 175(3) for exercising the power under section 175(3) BNSS, the condition laid down in section 175, 173(4) BNSS are required to be fulfilled. Post up. Issue notice returnable on so and so date. Up as Mr. Goswami has appeared. Accepted. Respond number 1. A petitioner shall take steps for service of notice upon the respond number 2 by registered post. Usual process 3 days. Firstly to the petitioner submitted that in connection with in connection with so and so case number, the petitioner was arrested and thereafter released on bail.
Not a SN, AB, my lordship, kindly.
Petition. Petition.
Page 31, lordship.
Petitioner has already joined the investigation. Joined the investigation?
Yes, Lordship.
Is it not? Cooperate with the investigating official? Absolutely so. I find privacy force in the submission of the as regards non-compliance of the provisions contained in section 173(4) read with section 175(3) of the BNSS. Having regard to the same, it is ordered in the interim that further proceedings, so the operation of the interim order dated 2/6/2025 and the consequential and subsequent proceedings shall remain suspended till the returnable.
Item 14.
This case, my lord, what there's a technical defect in this case, my lord. I ought to have challenged the order of cognizance. That has not been done, so I may be allowed to withdraw the case, ma'am.
Mr. P. Pakoki, learned counsel appearing for the petition has submitted that certain inadvertent error has crept in the petition, and therefore the petitioner wants to withdraw the petition with the liberty to file a press. And Mr. Goswami, an additional public prosecutor who is in attendance, has submitted that the state has no objection to the prayer In view of the above submission made by Mr. Kodogil and counsel for the petitioner, the petition is dismissed from withdrawal, with the liberty, as paid for.
For admission, item 19,
আগতে মই কেইটামান পঠাই দিছিলো এইটো কেছৰ Yes.
Negotiable Instrument Act.
One point regarding one point. So Lordship, I am submitting some of the judgment. The original copy. This is the original copy of the power of attorney. Lordship has asked me to submit the last occasion.
Where it was, date and signature. Where is the date?
It is not. It is not.
My prima facie suspicion turns out to be true. This is a doubtful document. A vendor issuing. In fact, he is not a vendor. Is he a vendor?
Issued by the bar.
General Secretary, All Manipur Bar Association. Is he a stamp vendor? Huh?
How if he is issued?
This is doubtful. An advocate cannot be a stamp vendor.
Yes.
General Secretary Bar Association, if it really exists, he must be a practicing advocate. Can he be a stamp vendor? Doubtful. Keep this original with you. I don't know what purpose it will serve. Okay, for the time being.
Lordship, regarding the question of the authorized, whether authorized signatory being a accused of the, whether authorized signatory. of the check
Signatory
of the
under NI.
check, NIA.
Hmm.
So Lordship may
Authorized signatory who has issued the check.
whether he should become a party under the. So this question raised in the Honorable Madras High Court. Lordship will find page number 1.
When there are authorities of the Supreme Court, why you are relying upon Madras High
Supreme
Court?
Court is there. I'm coming on.
Come to the Supreme Court directly.
Yes. Supreme Court has, that is page number. Page number 30. The Supreme Court judgment, your Lordship will find.
But keep in mind, keep in mind, before that, this is a proprietorship firm, not an incorporated company. Right. Now, you are taking me to page 30.
Page 52.
Page 50.
Para 66.
Page 52. Let us see the first judgment itself.
Yes, yes.
Head notes.
Yes.
Okay. Vijay Kumar Moni.
Yes, Lord. Para 60.
No, first, before going to para so and so, analysis.
Your Lordship.
First, come to page 30.
Page 30. Page 30. This
Better to have a better foundation.
Yes. Section.
No, Roman 2, analysis. We'll look into that.
Yes. Whether authorized signatory of
a
company.
Company.
All
We are not
field in-
dealing with company.
I'm not dealing.
Where is the answer to that?
Answer is coming.
Ah.
Meaning
Which
of
page?
page number.
Para?
Para 66.
Para 66.
Page number 52.
The position of law, as has been settled by this court and reiterated in a region of decision, is that it is only the drawer of the check who can be held liable for an offense under section 138 of the NI Act. Further, this court has also declared through several pronouncements.
Where the analysis starts?
Analysis stands from 63. There are 63.
No, 59.
Before we part with the matter, we deem it necessary to address the argument advanced by the counsel appearing for the accused that object of section 38 of the NI Act would be defeated if cases like present
Come to page 50.
50.
This is a discussion
Yes,
on section 141. And
140.
the entire discussion is on section on 141. Let us see 141. Because we are not dealing with company here.
No. We are here for the operatorship firm. Offense by company.
And you have stepped into the shoes of the proprietor by signing the check
Yes,
with seal and signature, declaring yourself as a proprietor
but here,
in a check.
here the plain reading. If
And
we-
and on the strength of this doubtful document, now you are taking a plea. And those are private documents. Had it been an incorporated company, your, say, withdrawal from directorship would have been uploaded in the website. And this is a document which can very easily be created. Right? That is why I asked you to produce the document. And now it turns out to be a document issued by an unauthorized person. Right? So that document cannot be given credence, no credibility with your plea regarding on so-and-so date, I withdraw on so-and-so. Now this 141, the heading, nominal heading, offenses by companies. So this interpretation, the entire discussion by Honorable Justice Padiwala is on section 141, which is redundant in the case for the case in hand. Am I clear? This nominal heading is offenses by companies. You had a look, Mr. Bhatti, to the document. Okay. So this analysis is not there. Anyway, let us see from page 50, para 59. If it is something there for individual.
in Onita Hada Supra, this.
Onita Hada, okay.
This code.
Company, this is company.
Company. 45.
Para 60.
There are following the company.
Company. The Ashok Transport Agency, 2005 manas. Company. Then para 61.
Sure.
Same. 141. Right. Responsible to the company. Then 62. The decision regarding company.
Company.
Company. Answer lies there. Come to page 6, page 63.
That's it. Yes, Lordship. But here the petitioner,
Look up, page 52.
page
Page
50,
52. You read slowly.
from
First line. The council.
the council placed reliance on a decision rendered by a learned single judge of a Madras High Court in a case of P. Sarvana Kumar, but so and so. The state decision was rendered.
Mr. Bhatti has a judgment. Bit louder. The said decision.
The said decision was rendered in a petition filed under section 482 of the CRPC for quashing of the private complaint filed against the petitioner therein for the offense under section 138 of the NI Act. The petitioner therein who was arraigned as a
Second accused, like here.
like here.
Read.
Second accused in the complaint has filed the petition seeking quashing of the complaint on him on the ground that check which came to be dishonored was signed by him in his capacity as an authorized signatory acting on
behalf
of the owner of the proprietary rights concerned, and thus he could not be said to have drawn the check on an account maintained by him, and the liability under section 138 could only be affixed on the owner of the proprietary concerned. It was also contended by the petitioner therein that the provisions of section 141 of the NI Act would have no applicability to a case involving proprietorship concern, as the same is not owned by a collection of individual by a single person.
Then next paragraph.
Yes. The High Court, while rejecting the contention of the petitioner therein, adverted to the object of section 138 of the NI Act to hold that the authorized signatory could be said to be the drawer of the check, as he was maintaining the account held in the name of the proprietorship concern, and thus could be held liable under section 138 of the NI Act.
Any difference? Any difference?
But Lordship,
no difference.
This is from the Madras High Court.
Right. This is the proposition I have been saying. Exactly similar to that.
Similar.
Madras High Court. Okay.
But later on it was changed. We
We'll do
find
that.
it difficult to subscribe to the view taken by the High Court in the aforesaid decision. High Court referred to an extract from the 11th edition of the commentary on the NI Act by Vaisham and Adiga, wherein the liability of the principal for the act of the agent has been discussed and erroneously relied upon it to attribute liability to the petitioner therein who was the agent acting on behalf of the proprietorship concern. The position of law as has been settled by the court and reiterated in a region of the decision is that it is only the drawer of the check who can be held liable for an offense under section 138 of the NI Act. Further, this court has also declared through several pronouncements on the subject that an authorized signatory acting on behalf of the principal cannot be said to be a drawer of the check on account maintained by him with the banker under section 138.
Okay, 1 minute. An authorized signatory acting on behalf of the principal cannot be said to be the drawer of an account maintained by him Yes, let us see. First,
Well-
let us see the complaint.
If we read section 138,
Now, let us see the first facts here. Page 13 is the complaint. Page 13 is the complaint.
yes, sir.
All checks are of 50 lakhs. Regarding compliance of that service of notice, filing of complaint, these are not in dispute.
My status is there. I am not the proprietor. Why I am?
We'll
Yeah.
do, we'll come to let the facts be there.
Yes, sir.
Now, where is your reply to the notice?
Yes. Page 40.
Page 40. So that plea that Zoyananda Singh was not the proprietor of Messrs. Li
LI
Steel,
It was not taken.
not taken. So the plea taken is that the account was closed much earlier,
Yes.
checks were issued much earlier, and closure of the bank account was intimated to you, and we have already cleared liabilities. These are the pleas you have taken. The plea which you have now taken was also existing at that point of time, because as per your, give me that document once again, as per your document now, which has been made the basis of this criminal petition, it was in as far back as in 2021. But that ground was available to you, but that ground was not taken. Seeing the nature of the document, which is not of sterling or unimpeachable quality, can it be a ground to institute criminal petition invoking 482? Yes, document outside the materials on record can be taken sometimes if it is of sterling quality or it is a public record known to all. This is very private document. Still, we wanted to see whether can it be taken in the category of sterling. So it is exactly opposite to sterling. Now, coming back to the plea,
At that
you
11
projected yourself.
At that 11
Now,
point of
now coming back to, because on the strength of that doubtful document, you projected yourself not as the proprietor of the proprietorship firm, and you projected as the authorized signatory. So all these observations in this judgment are not applicable, because the authorized signatory has been explained in case of private firm, but it is not your case. Your case is distinguishable. Every plea is open for you to raise before the trial. All are available. You have number of pleas, but all are matter of evidence to be appreciated by the trial court. If you can rebut the presumption, well and good. Otherwise, compliance of the procedure that placed, issued checks, you have admitted on the basis of proprietary, and your reply is, under instruction of my client, Messrs. So-and-so.
No.
Reply to your
No,
notice.
his
I have
notice
read
page
page 40,
35.
40.
No, 35 is reply on behalf of the Mr. Sri L. Joyananda Singh. Page
Hmm?
35.
Page?
Page 35. The two separate reply was sent.
Okay, let me read.
Uh,
Where you have said, where you have said,
it is not mentioned.
reply on merits. No, sir, that is also not there. You
This
individually
plea-
also replied to it. It did not say that I was not the proprietor,
This plea was
not taken. You raise this plea before a trial court. It is a matter of evidence. Yes. Anything else? Anything else from these judgments?
Current lordship is in our favor.
Now,
If
this
we-
explanation I have found
If we
not
able to-
applicable to you.
If we able to prove that I am the authorized signatory, then all the judgment in favor of us.
But it is not.
Here,
Prior to commission of the offense, it was not the plea. It is a plea taken subsequently
absolutely,
on the basis of a document
document.
which is of doubtful nature. Acceptability of this document can be made by the trial court. I am not jumping to the conclusion. This document, this 10 rupees, I can only opine that it is not of sterling quality. So that otherwise your case would have fallen as observed
Yes.
on the basis of the analysis made by the Honorable Supreme Court from that Madras High Court.
First, start from Madras.
Starts
From Madras.
ending in paragraph 68, and these facts are distinguishable from your case.
But lordship,
Otherwise, I would have admitted that yes, you have made out a case. But
as per
your
the
plea and
document,
reply are part of the record now. Nowhere you have taken the plea. And the check is clear.
check was issued.
Check is clear. Proprietor Joy Chandra.
But at
Yes. Anything else?
at that 11th point of time, lordship, they have sent only the notice, and in the notice, everything was
No,
not-
we are considering on page 27.
yes, check is
And your replies. Anything, sir? Others are similar?
yes. Say, all are sent.
Close this. The petitioner has instituted. Any other cases are there?
Okay.
How many?
They-
Before
they
this
filed
court?
14 to 15 cases.
How many criminal petitions?
Cumulative 4.
Has instituted these 4 criminal petitions under Section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023. Please write down the number, complaint case. You give a table, check number, date, complaint case. Write down. Seeking.
My lord, with the permission to close.
You want to go out?
Yes, only.
Seeking setting aside and quashing of criminal proceedings of 4 complaint cases, namely NI case number 6098 of 2023, Roman 1, Roman 2, Roman 3, Roman 4, which are presently pending before the court of one court, one court?
No, separate court.
It was available, which are,
Judicial magistrate first class, all are judicial magistrate.
okay, which are presently pending before the Court of Judicial Magistrate First Class, Kamrup Metro at Guwahati. Trial court, for short. Full stop. All the aforementioned complaint cases have been filed by the respondent number 2, a partnership firm, as the complainant, alleging commission of the offense under Section 138 of the Negotiable Instrument Act 1881 as amended. Full stop. For the purpose of appreciation of the issues raised in common issues raised in these 4 criminal petitions, the facts, the criminal petition, the facts narrated, the criminal petition, criminal petition number 915/2024 is taken as the lead case, and the facts narrated therein are taken into consideration only as other than the checks involved. There are no significant distinction and distinctions and difference in the facts involved. Full stop. Para. In the complaint filed in NI case number 6098, the respondent number 2 as complainant have arraigned Messrs. L.I. Steel, a proprietorship firm, as accused number 1, and the petitioner herein as accused number 2. Full stop. In the other complaint cases also, the same two, Messrs. L.I. Steel and the petitioner have been arraigned as accused. Full stop. In all the complaint, the petition number 2 is shown as the proprietor of the accused number 1 proprietorship firm, Messrs. L.I. Steel. Full stop. Para. In the complaint of NI case number 6098/2023, it has been asserted that the complainant is a partnership firm registered under the Indian Partnership Act, having its principal place of business at Guwahati, and it it carries on. It deals in sale and supply of cement. Full stop. The complaint is for the purpose of the proceedings, the complaint firm is represented by its authorized representative. Full stop. Subpara. It is further asserted that the accused number 1, Messrs. Li Steel is a partnership firm having its principal place of business at Imphal East, Manipur.
Not partner, not partnership,
Proprietorship. And the accused number 2 is the proprietor of the accused number 1 proprietorship firm. And full stop. Accused number 2 is a resident of Imphal East, Manipur. Full stop. Subpara. It is stated that during the financial years 2020-2021 to 2022-2023, the complainant supplied cement to the accused on credit basis to the extent of rupees 36 crore 47 lakh 39,907. Full stop. Against the cement so supplied, the accused made payment from time to time, and the complainant had acknowledged to have received an amount of rupees 33 crore 94 lakh 25,173. Full stop. According to the complainant, an amount of rupees 2 crore 53 lakh 14,734 remained outstanding and receivable by them from the accused towards payment of full stop. It is further stated that another amount of rupees 2 crore 63 lakh 59,236 had accrued towards interest for delayed payment till 7/8/2023. Full stop. The complainant had thus projected that an amount of rupees 5 crore 16 lakh 73,970 remained as outstanding and receivable from the accused. Para. Subpara. The complainant had further stated that as part payment towards 5 crore 16 lakh 73,970, the accused issued a check bearing number 884310 dated 22/08/2023 for an amount of rupees 50 lakh in favor of the complainant from an account maintained at Imphal branch of the State Bank of India. A check number 22/8/2023 ভিতর ব্র্যাকেটত দিব subject matter of NI case number 6098/2023. Full stop. Subpara. It is, the complainant has further stated that on presentation of the above check, at its banker, comma, SDFC Bank, comma, Guwahati Zoo Road branch for collection, the same was returned unpaid by the banker of the accused, citing region, comma, quote unquote, account close, and the complainant received the check return memo from its banker on 23/8/2023. Full stop. On receipt of information of dishonor, comma, the complainant through its lawyer sent a legal notice to the accused demanding on 2/9/2023, demanding to the accused, demanding the payment of rupees 50,000 within 15 days from the date of
50 lakhs.
50 lakhs. Within a period of 15 days from the date of receipt of the legal notice. Full stop. The complainant has further asserted that the legal notices were delivered to the accused on 9/9/2023 and 26/9/2023 respectively. And in support of the said fact, in support of such claim, comma, the complainant placed reliance in track consignment reports of India Post. Where the accused, on receipt of the legal notice, comma, sent two replies, comma, both dated 16/9/2023. Full stop. One reply has been sent by the petitioner, and the other reply has been sent on behalf of Messrs. M.I. Steel. L.I. Steel. Full stop. The stand taken in the said replies to the legal notice would be adverted to in the later part of this order. Full stop. Para. The complainant has further asserted that when it did not receive the amount towards this dishonor check, even after waiting for 15 days from the date of receipt of the legal notice by the accused, it instituted the complaint before the trial court. Full stop. Para. The learned, I have heard Mr. S. Das, learned counsel for the petitioner, Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam, and Mr. O.P. Bhatti, learned counsel for the respondent number 2, press complainant. Full stop. The learned counsel for the parties, for the petitioner and the respondent number 2, that's complainant, have submitted that how many? 12 litigations are pending between the parties in respect of 9 number of checks issued by the accused, which on presentation stood dishonored. Full stop. Para. Mr. Das, learned counsel for the petitioner, has submitted that where is your plea now?
I'm
Where you have ever heard?
yes, Lordship. Yeah. In my grounds,
Grounds.
page 8.
The cases are at what stage? The complaint cases are at what stage now?
Just we have received the summon.
Okay. It is further submitted by the learned counsel for the parties that the learned trial court in the 4 complaint cases, involved herein, involved in these 4 petitions, has taken, after taking cognizance on the complaint for the offense under section 138 Act, has issued process for appearance of the accused before it, and on receipt of the process, the petitioner has instituted the present 4 criminal petitions seeking to invoke the inherent powers of this court under section 528 B and SS. Mr. Das, learned counsel, appearing for the petitioner, has submitted that the learned trial court has erroneously taken cognizance in the complaint cases without scrutinizing the factual aspects of the case. Full stop. He has contended that the petitioner, Sri Jayachandra Singh, is not the proprietor of Messrs. Accused number 1, firm, Messrs. L.I. Steel. Full stop. It is contended by him that the concept of vicarious liability in the case of proprietorship concern is not applicable, since a proprietorship concern does not have a separate legal identity from its proprietor. And therefore, the concept of vicarious liability contained in section 141 of the Act cannot be made applicable in the case of the petitioner. Full stop. He has further contended that only the proprietor, in case of proprietorship concern, only the proprietor can be held liable under section 138 NI Act. Full stop. You have submitted some replies also, right? Which is your document?
My documents onwards, page 86, annexure 3, from the trade license.
80?
No,
Six.
86.
86.
Yes, Lord.
By referring to a trade license number, page 86, 21 DC IE 2016. Hey, Rukmini to Rukmini to issued by the office of the Deputy Commissioner, Imphal East District, in the name of Lei Tong Jang Inau Singh,
Right on.
the petitioner has contended that where is LI still? Okay. Contended that the said trade license having been issued in favor in the name of Messrs. LI Steel with Leitong Jam Inau Singh as its proprietor since 14/6/2016. Correct?
Yes.
26/4/2016. The petitioner cannot be arraigned as an accused in the complaint cases. Full stop. It is the contention of the petition that he was only an authorized signatory on behalf of the proprietor of Messrs. MI Steel, LI Steel, to issue the check. And therefore, the petitioner, being not the proprietor of Messrs. LI Steel, cannot be arraigned as an accused. Full stop. In contending so, Mr. Das has submitted that the criminal proceedings of these complaint cases are not sustainable against the petition. Full stop. Mr. Das has also referred to a decision of the Honorable Supreme Court of India in Bijoy Kumar Moni versus Paresh Manna, 2024, SCC online SC 3833. Para au contraire, Mr. Bhatti, learned counsel, appearing for a respondent as complainant, has submitted, has referred to the replies, dated 16/9, both dated 16/9/2023, to contend that in both the replies, the accused number 1 and the accused number 2 had admitted that the complainant firm and the accused number 1 firm had business relationship for sale of Ultratech cements in the state of Manipur. Full stop. The accused had further admitted regarding the position of the accused as the buyer of cement from the complainant firm. Full stop. He has further contended that in the replies, the accused had admitted about outstanding liabilities with a reply that all the outstanding liabilities were cleared after issuance of the checks in question. Full stop. Mr. Bhatti has further submitted that the accused did not refer to any document in support of their claim that they had cleared the outstanding liability. Full stop. It is further contended that should you refer to that document, your doubtful document? Have you relied here?
Yes.
Where is that?
Yes. Page number 1991.
91.
Annexure 4. Because only from only this document is now become the
তার এই দাসর সাবমিশন লিখিব Mr. Das has strenuously contended that the petitioner was once authorized by the proprietor of Messrs. Li Steel to operate the concerned bank account account number 3131-619-5821 maintained by the firm at the State Bank of India, main branch, MG Avenue, Imphal. Which is operated in the name of Messrs. Li Steel. Full stop. He has placed reliance in a power of attorney executed by the proprietor of Messrs. Li Steel, Laiton Jam Inau Singh. In a on 10/1/2011 on a non-judicial stamp paper. Then what is your subsequent? He has further referred to another document annexed as Annex 5 to the criminal petition to submit that by the said document dated 1/2/2021, Laiton Jam Joychandra Singh, proprietor of Messrs. Li Steel, wrote to wrote by which কি করলো line to dated referred to so-and-so to submit that by the said letter dated 1/2021, the petitioner resigned from his position of general manager from Messrs. LI Steel, effective from 1/2021. And the fact of resignation was accepted by the proprietor in writing on 8/2/2021. Full stop. Thereafter, the matter of resignation was duly intimated to the banker of Messrs. LI Steel on 9/8/2023. No. Duly intimated to the full stop. By projecting as above, it is contended on behalf of the petitioner that at the time of dishonor of the checks in question, the petitioner was not related with Messrs. LI Steel in any manner, and therefore, the petitioner is to be extricated out of the liability in relation to out of the liability under section 138 of the Act. Post. He has further contended that the documents whereupon the petitioner has placed reliance cannot be looked into in a petition filed under section 528 BNSS as the veracity, genuineness, and evidentiary value of these documents are yet to be gone into. In a rare and exceptional case, a document, it is true, are yet to be gone into. He has further submitted that these documents are of doubtful nature, and it is the trial court who will be best positioned to look into the veracity and acceptability of this document. On the basis of the facts presented in the complaint, it is evidently clear that all the necessary compliance have been made by the respondent number 2 as the complainant, and as such, no interference is called for at this stage. I have heard the learned counsel for the parties, and I have gone through the materials brought on record through their pleadings. The complaint filed in all the complaint cases, including NI case number 6098 of 2023, are part of the case records. The checks involved comma, and legal notices issued from the end of the complainant, response number 2 dash complainant firm, and the legal replies of the accused are also available on record. So I have gone through the contents of the same. Full stop. Para. The learned counsel for the parties are not in disagreement on the point that the conditions required, they are not contesting on the points of filing of the complaint cases, comma, issuance of the checks, comma, presentation of the checks for collection, and consequent dishonor of the check on the ground mentioned, comma, the legal notice issued by the respondent number 2 dash complainant firm and their receipt thereof, and the replies given by the accused to the legal notices, and the receipt of those legal replies by the respondent number 2 complainant. Full stop. Para. From a plain reading of the check bearing number, checks involved in these proceedings, it is evidently clear that the checks were issued in the drawer of the the drawer of the checks was shown as quote M/S LI still PROP L full stop Jayasandra JAYA Nondo NANDA Singh. Where it is exhibited, it is now, evidence is already, in the, okay.
The time of filing.
Full stop. Para. The grounds urged for quashing and setting aside of this criminal proceeding, the criminal proceedings of the complaint cases have been adverted to, are clear from the submissions of Mr. Das, learned counsel for the petitioner, comma, as noted above. Full stop. When the replies comma dated 16/9/2023, comma dash 1 from the end of the accused, one given from the end of the accused number 1 firm comma LI still, and the other given from the end of the petitioner dash it can be noticed that the contentions raised therein are similar. Full stop. At the cost of repetition, comma, it can be stated that there was admission as regards existence of business relationship between the complainant firm and the accused number 1 firm. Full stop. The accused number 1 firm was admittedly purchaser of cement, Ultratech cement in the state of Manipur from the complainant firm, Messrs. Prague, India. Full stop. There was no whisper in either of the two replies that the petitioner herein had signed the checks only in the capacity of an authorized signatory of accused number 1 firm and not in the capacity of its proprietor. Full stop. Document. The sheet anchor. Where the sheet anchor for the petitioner to institute these complaint petitions, criminal petitions, is a purportedly a power of attorney. Where it is annexed? Comma, annexed at page number 91 of the case papers. Case papers, no, in criminal petition number 915, 2024. Full stop. Oh, Bhati Savara. The petitioner is incidentally the son of Sri Laitonjam Inao Singh, the proprietor of of Laitonjam only Inao Singh. Full stop. Fair. It is a settled proposition that and a proprietorship concern does not have any separate legal identity from its proprietor. Fine. उल्टू से ऐसे हाँ हाँ just it very well. Interline. Raghu, right? You relied on Raghu. Rakhido. Line Rakhido. The complainant has arrayed Messrs. Ally Steel, a proprietorship firm, as the accused, number one, in each of the complaint. Post up. Para. The question raised herein is that the petitioner could not have been roped, could not have been arrayed as an accused, as accused number 2 in the complaints lodged by the complainant firm on the ground that he is merely an authorized signatory and not the proprietor of the firm. Full stop. On perusal of the checks which were dishonored, it is clearly evident that the petitioner had signed the checks as the proprietor of Messrs. L.I. Steel. Full stop. Does, the contention, does the checks, does the signatures and signatures, the petitioner is not denying the signatures appearing in the checks. Full stop. The signatures appearing in the checks go to indicate that he has signed, the petitioner had signed the checks as the proprietor of Messrs. Li Steel. Full stop. Does the checks, does the content, does such contention of the petitioner is belied by the facts facts which can be inferred from the checks under reference. Full stop. Para. On perusal of full stop. This court, in order to ascertain the contention raised by the petitioner, asked the counsel for the petitioner to show the original of the document wherein the petitioner has placed reliance to institute the instant criminal proceedings. First off, on perusal of the original of the document executed by Sri Laitonjam Inau Singh, allegedly when, sir? On 10/1/2021, the date of issuance of the non-judicial stamp paper is found missing. Full stop. It is noticed that the non-judicial stamp paper has been issued, has purportedly been issued by quote unquote ZEN full stop SECY, all Manipur BAR bar association ASSN, full stop. He has been a party in stamp vendor. His number is there. His number appears. Full stop. Para. In the said document by no stretch is a public document as defined under the provisions of the evidence sector equivalent to Indian Evidence Act 1872. Full stop. It is true that the width and amplitude of the powers, inherent powers of this court under section 5 to 8 PNSS which are akin to section 4A2 of the Code of Criminal Procedure, 1973, are unlimited. And whenever, in the interest of justice, the High Court, this court can make such orders as may be necessary to prevent thus to secure the ends of justice and to prevent the abuse of the process of the court. But the parameters to exercise the power are the parameters within which the powers are to be exercised are well settled by canon of decisions, including canon of decisions, including canon of decisions by long line of decisions of the Honorable Supreme Court of India and of this court. Post. The power of attorney purportedly executed by Laitonjam Inau Singh is not part of the records of the complaint cases. And the same is made part of these criminal petitions by the petitioner. For to invoke the inherent powers of this court. First of para. It is also too well settled that ordinarily, defense materials cannot be looked into by this court. Yes, in some very rare and exceptional cases, where the defense material, when shown, defense materials, which are of styling, quantity, and unimpeachable character, can be looked into. Full stop. But by no stretch, the document shown as the shown purportedly as the power of attorney placed before the court to further the case of the petitioner does not fall in the category of having sterling quality and of unimpeachable character. First off, the document evidently falls in the category of private document. First off, the question of the matter of acceptability, veracity, acceptability, and value, probative value of the said document can only be gone into by the learned. trial court in the course of the proceedings of the complaint cases, if such a plea is taken by the defense. Full stop. The other documents which are relied upon are found to be issued on the basis of the purported power of attorney. Full stop. Similarly, like the power of attorney, comma, the veracity, acceptability, and so of these documents also cannot be gone into. Full stop. Moreover, at the at the time of in these criminal petitions, moreover, comma, the documents where the petitioner has relied upon are documents which are exchanged between private parties. Full stop. Para. The decision, in the decision, Bijoy Kumar Moni Supra, relied upon by the learned counsel for the petitioner, one of the issues raised was whether authorized signatory of a company falls within the ambit of the expression quote unquote drawer question mark again unquote. The Honorable Supreme Court of India has answered the question there. Full stop. In the case in hand, the question no company is involved as the drawer of the checks. As the checks were drawn on behalf of a sole proprietorship firm. Clearly, the concept of vicarious liability embedded in Section 141 of the NI Act is not involved in the complaint cases under reference and these four criminal petitions. Full stop. In so and so Supra, the Honorable Supreme Court has observed that an authorized signatory acting on behalf of the principal cannot be said to be the quote unquote drawer of the check, quote, on an account maintained by him with a banker, unquote, under Section 138 of the NI Act. Full stop. The background facts which led which led the Honorable Supreme Court to make the observations, above observations, are different from the background facts involved in this complaint cases under difference. There's a slight difference in facts. It will be should fill up corridors. In the case in hand, the petitioner had issued the checks, which resonated on presentation for collection, as the proprietor of the accused number 1 farm. Therefore, and nowhere in the check it is mentioned that he had signed the checks in the capacity of an authorized signatory only. Full stop. Therefore, his position as regards authorized signatory is the fact whether the petitioner signed those checks either as an authorized signatory or as the proprietor of the accused number 1 farm as at the relevant time is a matter of defense which cannot be gone into at this stage. It is only after it is only on the basis of evidence laid during the course of the proceedings of the complaint cases the petitioner can rebut, can establish his defense. Full stop. Para, in view of the discussion made above and for the regions mentioned, assigned hearing, this court does not find any reason, much less good and sufficient, to invoke the inherent jurisdiction of this court available under 528 BNSS. Consequently, the criminal petition are liable to be dismissed, and it is accordingly ordered. As the issue involved in all the other 3 criminal petitions involved and raised in all the other three petitions are similar, which position has been accepted by the land council for the parties, the same are not discussed for the sake of brevity, and as most of the and in order and other than and the same would not made any difference other than other than there's the Mumbai.
Much of that.
Take back this, your seat anchor.
Much of that.
কোনটো আছিল কোনটো আছিল পাৰ্টি কোনটো আছিল okay. Who were in 30? 31?
Item 31.
Something. Because other matters are also there.
One matter. 31 is hearing.
Your matter, I think, na? That
Yes.
day?
Remember, my lord,
Remember, the only thing is
Yes, yes,
time.
yes.
Remembering is not the issue.
so many matters. The charge was framed under
Charge was framed.
409, it was then set aside. It was modified by law to 406 by law.
And Lordship,
Direction was issued.
and Lordship, on the last occasion, we are directed to take instruction whether respondent number 3 is alive or not. Lordship, we tried to contact him, but no any instruction.
No order to sound. Mr. Chaudhary,
Yes, ma'am.
there were how many accused?
3 accused by law.
2 are already gone.
Two lady.
They are in heaven or hell, whatever.
Fine.
And third one,
Yes.
status is not known.
My
If he is also gone,
No, no, my instruction probably he's alive, my lord. The official I required. Probably.
probably. Why should we make any futile exercise
Yes,
without
ma'am.
knowing the
Yes, ma'am.
we'll record that he is submitting on instruction that this and this gone.
Yes, ma'am.
And the status of this living status of this third accused is not known. He'll place instruction.
Yes, ma'am.
If he is also dead,
Yes. Otherwise, then everything will go.
what I had commented,
Yes,
your purpose is served.
absolutely. My lord, the other one, my lord. So we also wanted the trial should continue, my lord. Unfortunately, my lord.
Then in these words, collusion and connivance looks imminent. Because do you have any document that they have died?
Lordship, regarding Rambora, we have is that death certificate, Lordship.
Do you have death certificates?
No, only of Rambora, Lordship.
Ram Bora and the other Raskuar and Dotto?
Lordship, till now we had not received.
Okay, Mr. Chaudhary, you wait, we'll take some time. Let us other if new
My-
matters are there.
My lord, yes.
We'll make a vote, just wait for some time.
Item 23,
Why IA criminal filing number?
My lord,
Appeal is new. Appeal is new.
appeal is new, my
Or
lord.
admission today.
Admission for today, my
Okay.
lord, after condoning the delay, my lord.
What is the other IA?
Disposal, IA.
I wrote a disposal. I took it.
25, it is disposed, my. And another IA, my lord, filing number is 65.
The filing number, number one. Number one. Okay, we'll admit this appeal. This is to be registered.
Registered.
Appeal is registered, my lord.
Appeal is registered,
Yes.
IA is not registered.
Yes, IA is not
This IA is for what?
suspension of sentence.
You get it registered. You get it registered, then we'll
My lord,
take note of.
in this appeal. may
Okay,
be
we'll look into it. Hard miss.
BRS.
BRS Sultana Learned Counsel for the appellant, accused appellant. And Miss
No, sir.
Sir MP Goswami Learned Additional Public Prosecutor for the respondent. Number 1. State of Assam. Post. The instant criminal appeal under section 415 BNSS is directed against A. Judgment dated judgment and order dated 26/3/2025, page 9 of the same. Passed by the Court of Learned Special Judge Pokso Themaji in special Pokso case number 05/2024, which arose out of Silapathar Police Station case number 247 of 2023. By the judgment and order dated 26/3/2025, the accused appellant has been convicted for the
Yes, the.
for the where is that paragraph?
Rigorous.
For the offense under section 10.
Yes, my lord. Rigorous.
10,
imprisonment.
10. Section 10.
Yes, my lord. Under
Section 10,
of-
POXO Act.
Section 10,
And rigorous.
And he has been
imprisonment.
sentenced to
6 years.
undergo rigorous imprisonment for 6 years and to pay a fine of rupees 15,000 in default of payment of fine, to undergo rigorous imprisonment for 6 months. Full stop. The appeal, I've gone through the grounds urged in the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of sworn should be called for. Issue notice returnable 4 weeks. As Mr. Goswami, respondent 1, practice direction, officer in charge, Silapathar Police Station case. Get the eye register.
item 24,
This is regarding bank guarantee, madam.
Bank guarantee.
Yes, that matter, madam.
Okay. Yes.
Yes, madam.
Hey, Ratipa judgment could go. Hey, Ratipa to ask him. Ratipa to cycle. I'll not dictate the order.
Madam, I already did.
But you'll not get it today, tomorrow. Not tomorrow.
Fine.
Heard Mr. J. Ahmed. But the details,
Lordship.
because the other
Yes,
is
yes.
being made ready.
Ready, madam.
So I'll do the similar.
Yes.
Heard Mr. J. Ahmed, Learned Counsel for the petitioner, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state of Assam. Full stop. The instant criminal revision petition is preferred against an order dated 19/6/2025, whereby the Court of Learned Session Judge, Kokrajhar, Trial Court, granting interim custody of a seized vehicle to the petitioner, has imposed a condition that the petitioner shall submit a bank guarantee of rupees 7 lakh, which is equal to the value of the vehicle. Full stop. Mr. Amit, learned counsel for the petitioner, has contended that. Where is the charge sheet submitted?
Yes, Asit, my lord.
Subject vehicle, comma,
Page
with the
19.
details,
Page 19.
page
19.
19. No, seizure list. Any idea? Seizure list, subject vehicle, comma. No, subject, sorry. During the course of investigation of Kokrajhar Police Station, case number 72/2025, registered for the offenses under Section 303 within bracket 2 and Section 325 of the BNS Likhitivo, read with Section 13 within bracket 1 stroke Section 16. Assam Cattle Preservation Act, Sontu Saidibo. Read with Section 11(1) of the Protection of Cruelty to Animals Act 1960, comma, a vehicle within bracket Wagoner bearing registration number AS -16 stroke M -5457 within bracket subject vehicle was seized after investigation into the case, Command Ayuk laid a charge sheet. White SARS on 10/5/2025,
25, yeah.
finding privacy case against the accused against page 21 of a tickman আছে 1 2 তিনি 4 5 6 8 8 8 number of accused persons, namely Rustom Ali SK, এক number, within bracket the petition, within bracket the petition, তাৰপিছত 2 3 4 by কিনি লিখি দিব পেৰা। The petitioner, as the registered, claiming to be the registered owner of the subject vehicle,
I'm the purchase from the register owner. I purchased the vehicle from the register owner.
oh, okay, as a person
Paragraph 2,
paragraph 2,
yes, sir.
okay,
Model Ali Sheikh is
the petitioner
has
has stated that the subject vehicle was originally purchased by one Mohidul Ali Sheikh under finance. Post op. Subsequently, the vehicle was purchased by the petitioner from Mohidul Ali Sheikh by executing a notarized agreement on 10/12/2000, by an agreement dated 10/12/2024, which was notarized on 13/12/2024, by paying
1 lakh.
An advance consideration of rupees 1 lakh. With a further condition that the petitioner pay the remaining 84 number of installments to clear the finance. Full stop. Subsequent to the aforestated agreement, comma, the petitioner took possession of the subject vehicle. Full stop. Para. With such projection as regards the relation of the petitioner who are the subject vehicle, comma, the petitioner preferred an application before the learned no, line by the on submission of the charge sheet, comma, the case has been registered as Sessions T2 case number 76/2025. Post of para. Projecting such relation of the petitioner who are the subject vehicle, the petitioner preferred an application seeking inter custody of the subject vehicle before the learned trial court. Full stop. And the said application was the application preferred under section 497 BNSS was numbered as petition number 2072/2025. Full stop. On filing of the petition, comma, the report from the IO was called for. Post of the special court, the trial court. Recorded the fact that after completion of investigation, charge sheet was submitted and the trial has been commenced. Full stop. In such background, Commander trial court observing that further retention of the vehicle would not serve any purpose, and the vehicle can be used by the petitioner. The trial court directed for interim custody of the vehicle in favor of the petitioner, provided the petitioner undertakes to produce the seized vehicle as and when required by the court. Full stop. One of the condition imposed for release of the vehicle by the trial court is to the effect that the petitioner shall furnish a bank guarantee of rupees 7 lakh, which amount is considered equal to the value of the vehicle. Yes, bond.
Item 25.
Appeal admitted. Har Mr. R. Ali.
MZ Channel.
MZ Shah, learned counsel for the accused appellant, and Mr. B. Sharma, learned additional public prosecutor for the respondent state. Para. The criminal appeal under section 415. BNSS is preferred against the judgment and order dated 36/2025 passed by the Court of Session Judge West Karbi Anglong Hamrin Trial Court. In session case number 33/2023 within bracket TI. By the judgment and order dated so and so. The accused appellant has been convicted for the offense under section 304, part 1, Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 20,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. I've gone through the grounds urged in the memorandum of appeal. Appeal is admitted for, the criminal appeal is admitted for hearing. Case records of science to be called for, issue notice, returnable 4 weeks as Mr. Sharma. No formal notice. Is the case after 4 weeks. Yes. I
am, my lord. For
Let the
bail,
LCR
for
come.
bail, my lord.
Let the TCR come. Part M.Z. Shah, applicant appellant. By can লিখে দিব 430. As P. Sharma, opposite party or applicant লিখে দিব. The prayer for suspension of sentence will be considered after receipt of the TCR.
26.
Well, in this case, we have sought for Jimma of rupees 62,80,890. Initially, I was arrested, granted bail, and Your Lordship, on the last occasion, the report.
Yes,
has
sir,
come.
you will receive some report.
My lord.
This money was seized on 2/5/2024 by breaking open the lock of the almirah of the petitioner's house.
You have to, Mr. Kumar,
Yes.
can it be on some other day? They are objection at this stage.
Objection,
Right.
I can anticipate they will make general objection without.
Because,
Your Lordship will fix it on some other day, and Your Lordship will ask them to place the case diary also, because they have to justify from these allegations.
because at this, okay, little difficult, they are referring some enforcement director,
Yes,
income tax
they will-
department.
So
Get
I-
the case diary,
My,
I think it will be better.
my lord.
Lord, may I pray on any day on 28th or 29th of this month, subject to Your Lordship's.
Okay, yes, possible from which place?
Tinsukia, my lord.
Tinsukia.
Case diary,
Is there, my lord?
29?
29.
Yes,
Would be, I think, next
Yes,
Friday.
man.
yes.
On fifth, man.
Fifth.
night.
Yes, Mr. Kumar,
My lord,
I think may not be convenient for him.
7.
7 is September.
Sorry, I'm looking at
Sunday,
5th.
5th Friday. Okay. You need a case diary.
My
Yes,
Hard,
this case diary,
Mr.
simply
B.
making those
Ethan.
high sounding words without supporting it by the case diary will not suffice their purpose.
Yes, senior counsel for the petitioner and B. Sharma learned additional public prosecutor for the respondent state. Mr. Sharma has submitted that he has received a report. But in order to make further submissions, the concerned case diary appears necessary. Those of as sought for by Mr. Sharma for production of the case diary, lays the case on. To obtain the case diary, lays the case on 5/9.
This report can be furnished. I think it's nothing secret about them.
No, I have not seen. Let the
Later-
case diary be there.
Yes,
Yeah, well, details will be there.
we are blessed.
Item 27.
Please, your lordship. Criminal petition is against framing of charge.
Framing of charge.
My lordship. Only problem is, my lord, the case's trial is going on, my lord, and fixed on 28th, my lord, this month.
At this stage, we can't help it to decide about charge in what case? What case?
My lord, PC Act. my lord. Section-
PC Act.
Section 7. my lord.
It will be very difficult at this stage.
But,
I actually intend to take up that 2012 matter
my lord,
that is running for last 12 years. This is very fresh.
my lord,
You agree on some other date?
Lord, today, my lord, on 27 or 28, my lord, in was on
Yes,
28th.
Mr.
The
Hassan.
problem is that I'm representing the state as a special public prosecutor. Moreover, as it appears from the report of the section that the trial court records is yet to be received.
It is called for.
I think, yes, for proper adjudication of the case, the trial court records will be required.
Special judgment.
Special judge
Ah.
court. So may I humbly pray?
Oh, no, Kaladnama. We was supposed to file Kaladnama.
Supposed to file Wakalatnama. Lordship, what has
You are
happened?
what? In what capacity?
For
Respondent
respondent
number
number
two.
2, Lordship, the informant.
Huh?
The informant.
Informant.
Yes. Now, Lordship, what has happened, Lordship? I had.
Section 7 is what?
Section 7 is taking gratification or attempting to take gratification in the as a reward for doing the things improperly or dishonestly.
Okay. You have not filed Kaladnama?
Lordship, I have filed the Wakalatnama. Now, what has happened, Lordship, in the computerized section of the order, Lordship, the name of the respondent is shown wrongly, Lordship. Actually, his name is Ariful Haq, but his father's name is shown as respondent number 2.
That you rectify. Okay. Case record. Let the reminder be issued
My lord.
for case record if it is necessary.
Yeah, actually,
And-
at this stage,
Uh-huh.
for a date subject to the convenience of court on September.
Lord, was on
Ah.
28th. Witnesses been examined twice, my lord.
We
PW
can't
one.
help it, sir. Case records, if it is required really. This is not trap case.
This is
Not
for-
rape case, my lord.
This is
Say circumstantial evidence matter, my lord.
We don't know.
But that I'll
Will
place,
not
my lord,
say.
at the time of my lord. When this
Can it
matter
be
is
on
taken.
3rd of September?
Lord,
3rd of September till the 5th of September, subject to the convenience of the court as well as the other side.
Otherwise, I don't have any, my lord, problem with that, my lord. Only issue is, my
M.K.
lord,
Das, petitioner
28
K.
November.
Hassan, Land Special Public Prosecutor Assam, and B. Sharma, Land Counsel for the respondent number 2 are present. The scanned copy of the TCR was called for. First of the TCR as called for, as per office note dated 19/8/2025. The TCR as called for has not yet been received. First of office to issue reminder for the TCR as sought for and agreed to by the Land Council for the parties. List the case on. Yes, agreed to a present.
5th of September.
5th of September.
only, my lord, if, my lord, some accommodation, the court below, my lord.
What my learned
With
friend,
regard to cross-examination part.
what my learned friend wants to say, because the evidence is going on in the trial court. So the further examination is often fixed
Stalling a trial is very difficult.
My lord, on 5th,
on 5th.
how late?
Value placed.
Item 28.
May I please your lordship, my lord, instruction was sought for lordship. Last date, lord.
Let me read, then it will come to my mind. Yes, where is Mr. Kaushik? Sotendra.
Just to leave for some urgency, my lord.
Huh? He has left.
Yes, my lord. For some urgency, he has to leave, my lord.
Oh, he has left the court.
Yes, my lord, that one. Who has stated that instruction not received as per his,
What instruction?
there is.
You can answer.
Posted tomorrow. If
Mr. Goswami,
Lordship.
look at this order and tell me, as an officer of the court,
Lordship.
this WhatsApp is sustainable order.
Lordship.
That is why I call for Mr. Kaushik.
Lordship.
I
Yes,
think
he is
he was
aware.
in the case.
He is aware of the facts.
He was in the case.
Lordship.
Yes. Okay, next.
Item 29.
If you say as an officer of the court, then I'll
Lordship.
do it, otherwise I'll set aside. Yes, what is, that's interim, custody. Oh, you wait, you wait. No public prosecutor.
He is also in another.
He is also gone.
Lordship. He is in another court, my lord.
What is the condition here?
Here we have to call for the report once again, my lord.
Bank guarantee,
Bank guarantee, my lord.
Bank guarantee. For
same,
that case, my bank guarantee, same, my lord.
hard, Mr. N. Borua, learned counsel for the petitioner. And Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, Sirvasam. Hey, I had to put bank guarantee. Oh. Bank guarantee, Lushil, bank guarantee, kettle, huh? Let me read the order. Where is the order?
Impugn order is, my lord, page 20.
20, okay. The instant criminal petition under section 528 Bharatiya Nagorik Surakha Honita 2023 is preferred against a judgment dated 5/5/2025 passed by the Court of Learned Session Judge Ibohagor in criminal revision petition revision number 23 within bracket 3 of 2024. Full stop. The criminal revision was preferred against an order dated 3/9/2024 passed by the Court of Learned or Revisional Court, trial court of passed by the Court of Learned Chief Judicial Magistrate Ibohagor in PRC case number 204/2023 registered for offenses under section 379/411, Indian Penal Code, read with section 13 within bracket 1 of the Assam Cattle Preservation Act 2001, read with section 11(1)(d) of the Preservation of Animals to Cruelty Act. Preservation of Cruelty to Animals Act. Full stop. The subject matter of the order dated 3/9/2024 Supra and the judgment dated 5/5/2025 is a vehicle when you make a Tata truck bearing registration number AS-02/E-8236 within bracket the subject vehicle. Full stop. Search is submitted.
Yes, my lord.
Uh,
In the order, my lord.
Initially, sorry, the case, comma,
Case 19, my lord.
no, the police report case, written by PRC, number 204, 2023, arose out of Sipsagar Police Station case number 13/2023. Post op. In the FIR, first information report lodged in connection with Ibahagar Police Station case number 13/2023 on 1/2/2023 before the officer in charge Roy Hagar Police Station. The informant, Gautam Hendik, had inter alia alleged that at around 9:30 p.m. on 1/2/2023, he and his friends were at Hotiapar and they saw the subject vehicle passing ahead. Full stop. Suspecting the suspect as a suspicion arose, the subject vehicle was intercepted and the vehicle was driver was inquired. Post stop. It was found that the subject vehicle was carrying 24 number of cattle without any valid document. Post stop. The petitioner has claimed that he is the registered owner
Yes, my lord.
of the subject vehicle. It is on conclusion, after completion of investigation of Hibahagar Police Station case number so and so, the IO has already submitted a charge sheet. You are one of the charge sheet accused.
Yes, my lord.
Huh?
Yes, my
Against where is the charge sheet?
lord.
Any
Case
idea?
19, it was not
Not yet.
reflected in paragraph 4, my lord.
As
Yeah,
already been charged under against the accused persons under section 379/411 Indian Penal Code, read with section 13 within bracket 1 of the Assam Cattle Preservation Act, read with section 11(1)(d) of the Preservation to Cruelty to Animals Act. Post op. In the course of investigation, the subject vehicle was seized on 1/2/2023 by the seizure list, MR number 12/2023 from the possession of the driver of the subject vehicle. Post op. The petitioner has contended that at the time of seizure of the vehicle, the petitioner was not present. Full stop. By the judgment dated 5/5/2025, the regional court allowed the prayer for interim custody made by the petitioner by setting aside the order dated 3/9/2024, Supra, whereby the prayer for interim custody was denied. Full stop. The operative part of the judgment dated
Yes,
5/5/2025. Read as under paragraph, page 26 or paragraph 11. Para. There is no, it is clear that the case has already been charged. Para. The only contention raised by the petitioner is that the condition of imposing the condition imposed regarding furnishing of bank guarantee of rupees 10 lakh is as set forth in condition number 1 above, is not easy, full stop. It is and in fact, is harsh and onerous. Ba এখানে লিখে দিব indemnity bond. Itu যে judgment to in pagini common. Indemnity bond.
Yes.
Supplementary list, item 39.
Resolution.
Criminal
proceeding of PRC case number 702 pending before the learned additional CGM damage lordship.
We have to rise, Mr. Islam,
Lordship.
someday else.
That's one.
But
who I-
can't help it. I have something.
And
Mr. Sodri, not possible perhaps.
some other date.
Okay. This might be my end of my criminal journey. Criminal bench journey for the time being. So you choose your dates. I am giving. I am not sitting in criminal bench tomorrow also.
That extension matter, your lordship had heard day before yesterday.
I can.
That my lord, Tuesday, my lord,
I am not sitting in criminal bench.
some, we'll fix it, let it come as a fixed item, my lord.
Which one? Is it listed today?
They listed, my lord. Item 44 and 45. The lordship had heard it day before yesterday. At NDPS, my lord. extension.
Okay, one by one.
Item,
Mm.
this matter.
Mr. Chaudhary,
3 or 4. This matter lordship item 39.
1 minute, Mr. Chaudhary, your case.
Yes, item 31, Maharaj. Your lordship may heard the matter
Huh.
entirely. Your lordship may do one thing, my lord, for the interest of justice, my lord, 2012 matter. Can
Mr.
we-
Counsel, who is the respondent for the respondent in
Yes.
this case? The old case. He has gone.
31.
He has gone. Yes.
Yes.
Can you obtain the instruction about the status of the remaining respondent? Otherwise, we will pass the judgment.
My lord.
Yes, yes, yes.
My lord, one of the respondent number 3 preferably, my lord.
Huh?
He's alive.
He is alive.
He's alive. We have instructions, my lord.
Okay.
1 and 2.
Mukhi bench dile.
Respondent number
Why brought hearing man? You know?
Prakhanta
Okay.
Kumar, doctor, respondent number 3 is alive, man.
Yes, Mr. Chaudhary, we can put it on Tuesday.
My lord.
Part heard.
Matter, yes.
42, my
That will-
1 minute, 1 minute. Oh, your case.
42. Yes.
Okay. দুটা লিখি দিব কিমান আছিল এইটো 31 A Chaudhary for the petitioner And Mr.
M. Sharma.
M. Sharma. Learned counsel for the respondent 1 to 3. Hard, huh? As the submissions are not concluded, release the case on Tuesday, showing it as part heard. The case will be taken up at 3. Both 3.
Item
42. Yes, Mr. Goswami, are you ready with that?
But my lord, it's not hard, not being hard.
I have heard, I have read the file.
That is,
3,
yeah.
161,
Yes, ma'am.
Yeah, my lord.
2. You have read? Okay, then, same.
Yes.
Z. Chaudhary. Petitioner. These are new, sir. Very new. 25, yes. 2025.
Fishing proceeding,
Huh?
70-year-old man suffering from cancer and all, my lord.
Thursday. G. Chaudhary and MP Goswami. Oh, who is the respondent number 2?
Yes,
Oh, I did not see her that day.
sitting, she appears for the DSP, madam.
Huh?
She appears for the DSP, who is the complainant, and she was there also yesterday.
I did not see her.
She was there, madam.
Let me Thursday, I'll not make it part her. Then because Thursday. MP Goswami. Yes, next.
Lordship, item number 34, Lordship. There's an interim order, it will continue.
Huh?
There's an interim in that matter, Lordship.
Till date or what?
Till date, Lord. Yes.
Sound 34. Okay. When do you want?
Any date, Lordship.
You are Miss S. Parveen, learning counsel for the petition, Miss P. Chakraborty, learning counsel for the
Respondent.
sole respondent. Respondent number 2. Not present. As sought for and agreed to by learning counsel for the party, list the case on 23/9. Okay. The interim order passed shall continue till the next date of
Please.
That's 44 and my lord, I am 28, my lord.
39 to go by to. You do? Huh? So this is regarding what, Mr. Counsel? 39?
39, this is for proceeding, Lordship, criminal proceeding, Lordship, which is pending.
Criminal proceeding.
Lordship. Basically, the petitioner not supply the material after receiving advance money, Lordship, which is purely civil nature, Lord.
Did I hear it?
Earlier. Yeah,
Did I hear it?
Yes.
There is two. So there is 2 FIRs, Lordship. The second FIR he has got stayed, Lordship. The second FIR is stayed, Lordship. Second FIR trial is stayed, Lordship. And Lordship, the petitioner is also habitual offender, Lordship. So he has many cases, Lordship.
That is not a
Let me
factor.
finish. I submit.
I don't know এখন কি আছিল No, you choose your date. I'll be going to a different bench now.
Then the 39, Lordship.
Huh?
39.
39. Okay. Islam. MP Goswami লিখে দিব SK SN Mohammed. Okay. Lays the case as sought for and agreed to by the land council for the party. Lays the case on 39.
Much of it.
My lord.
Yes.
Item 28, my lord.
When do you want?
Any date, Lordship, interim may be continued.
Okay, as sought for by Mr. N.H. Borvian, learned counsel, but a petitioner lays the case on
3-9,
3-9.
interim, will be.
Clear, my lord, already.
Which one?
28 Lordship. That 28 your Lordship already have passed some order, Lordship.
Oh, until.
28,
Okay, put it. Part Hari.
part 5.
Tuesday?
Interim may be continued, Lordship.
1 feet, 1 feet.
The interim may be continued.
Huh?
Interim, Lordship. No coercive action. That is.
It was there.
Yes, Lordship, there.
Same, the interim order
Of course.
shall continue.
High level.
Yes, then what
44
your,
and 45, my lord, lordship had heard it, my lord, last week also, even day before yesterday also. That extension matter, my lord, Hitendra Vishnu Thakur and Sanjay Dutt's judgment.
did you get it?
Yes, my lord, I got that judgment, my lord, regarding that advocate, my lord. That judgment I have got, my lord. That if it's given to an advocate also, my lord, that will.
Who is the other side?
Bonkim Sharma was.
Yes, Mr. Goswami.
Is a extension of his- So, lordship,
এটা কাম কৰ চব হেৰি দি দিয়ক টিউজডে দি দিয়ক ক্লিয়াৰ কৰি থৈ দিওঁ আৰু আকৌ বা কি ইভেণ্টছ কৰে থাৰ্ছডে at 3
my lord,
as now as item number
44 and 45.
for further hearing for you. Okay. Anything?
No, my lord, deep level.
Other?
And
My
I
lord,
now
I-
43, 46 on order.
Which one?
43, my lord.
43.
Yes.
What do you want?
For Jimma, my lord.
Oh, Jima.
Yes,
Yes.
that case, my lord.
Cattle.
Yeah, not cattle, but the vehicle.
Vehicle, my lord.
Vehicle, the vehicle, he's the owner, but his
Mr.
name is not forwarded for trial, my lord.
What to do?
He won Jimma.
Next
A date may be given.
Thursday. Mr.
Z Taku.
Z Taku, MP Goswami. This is the case on Thursday, huh?
May I please? I beg
Replacement.
item number 40, lordship,
40.
40.
Yes, what do you want?
Sort of claiming juvenility law.
Okay. On the prayer of
Suspending
Mr.
of this
Mr.
R Hawk law.
Don't argue on submission, merit.
Mention for
R Hawk.
R Hawk.
Yes, please the case on. Yes, Mr. Goswami.
Any
MP
date.
Goswami.
lordship,
Please the case on Saifal Didi Batate. Yes.
There is an IA item 30. This second IA, my lord. First was one.
Okay, please the case on the prayer of Mr.
SS Ahmed, my lord.
Please the case on.
In the meantime, my lord, they may be allowed to file.
Next week, I'll do it.
A date may be given.
Next week.
May please your lordship, item number 33, my lord. Criminal appeal, my lord, fixed for hearing, my lord. Any other date may be given, my lord, kindly.
Hearing is not a fixed date. Not fixed. It will roll over.